Hang on, I'm looking. Got to get the app.
I'll make sure that you can hear it.
Testing 1, 2, 3. Testing 1, 2, 3.
Morning, everyone. We're here today for oral argument. We are going to begin with Appeal 24-2254, SEC et al. Versus Duff et al. We'll begin with oral argument from the appellant, Mr. Is it DeVoot? DeVote, thank you.
May it please the court.
Yes.
Good morning, Your Honors. My name is Andrew DeVote, and I represent Shatar, the appellant in this case. Your Honor, Equity Build, this is the second time that Equity Build's fraud has come before this court. A fraud perpetrated over the course of nearly a decade that had more than hundreds of victims, carried about professional liars, robbing them of tens of millions of dollars. In fact, as this court specifically found, Equity Build's purpose business model was to obfuscate and mislead when it came to ownership and responsibility for property. Against this backdrop, Your Honor, this morning, given the timing, I'd like to focus on two specific issues. The first is the district court's determination that Shatar, once on inquiry notice, through a diligent inquiry, would have learned certain facts that would lead it to learn that there were other individual investors who already had mortgages on the two properties, Yates and Indiana, such that Shatar did not have priority, despite having recorded its mortgages some 3 months before the individual investors' mortgages recorded. Your Honors, we know, well, first, Shatar disputes its inquiry notice, but we know that the district court erred with respect to its determination on the diligent inquiry and what would have been found, because the three suppositions the district court makes on pages 32 and 35, there's three main points in terms of what would have been found by a diligent inquiry are belied by the extraordinary facts actually in this case. Specifically, the first on page 32 is that if Mr. Namvar from Shatar would have asked for proof that the loan on the Yates property had been paid off, that he would have been provided information demonstrating there were individual investors with that loan and that there were no rollover documents. But Your Honors, we know we don't have to speculate that that's not what would have happened here. This court on the Group 1 appeal specifically noted that when faced with this exact problem, competing secured interests, Equity Build created false payoff letters with respect to Group 1 properties, indicating that another investor's loans had been used. So there's no speculation here as to what would have happened. We know that had they were asked a question about proof of paying off the loan on Yates, that what it would have been provided would have been false documents. The SEC tells us that as well, that even on
Counsel, did you make this argument below to the extent that you're making it here?
Your Honor, absolutely not. We made the argument in terms of inquiry notice.
What exactly, spell out for me below what your argument was on inquiry notice, because
Yes.
I don't recall this specifically that you're
Yes, Your
saying
Honor.
here today.
So on document 1587, pages 7 through 11, we set out the framework for inquiry notice. And Your Honor, remember, this is a staggered briefing in this case with different filings. And in a reply briefing, respond to the idea that they were on inquiry notice and specifically say that Shatar was not on inquiry notice as to either property. And even if they had been, that any inquiry on the title search index would not have revealed that there are these prior mortgages. I think the key point, Your Honor, is that on page 29 of the district court's opinion, the district court disagreed with what we consider would be the scope of the title search that would take place in inquiry notice. The district court specifically citing Inouye County Collector and other cases says in Stump that it can go beyond and what it would look at for inquiry notice and whether or not there would have been facts discovered on diligent inquiry. We disagree with that scope, but now on appeal, we're focusing on the points the district court made as to why it thought what a diligent inquiry would have found. So we absolutely made the inquiry notice argument. Respectfully, I did not anticipate the district court would suggest going to Equity Build for the very reason that our four contacts, the Cohens, Mr. DeRue, and Mr. Mora, they're all fraudsters. And that's not Shatar saying that. That's the SEC. That's the Receivers Council. The Receivers Council sued Mr. DeRue for his involvement in this fraud. And just this summer, Mr. Mora, the receiver, implored the district court that he should not receive any proceeds from any sales because of his active involvement in the fraud. So on appeal, we are addressing what the district court said it believes would have been found on a diligent inquiry. But we absolutely did not anticipate that it would have suggested that was a part of the diligent inquiry. And so there is no waiver, Your Honor, and it's simply addressing the court's reasoning. The second supposition the district court made was if Mr. Nambar would have talked to the investors, it would have found out, the individual investors, there were other mortgages. But the problem with that, again, is Mr. Nambar didn't know that there were these individual investors, that they existed, or who they were. And that's by design in this fraud. In every other context of this case, the receiver, the individual investors are all more than happy, the SEC, to talk about the scope of this fraud that lasted for a decade.
But counsel, one of the principals, if I'm not mistaken, sent an email saying they had become aware of the business structure, and that raised some red flags. They certainly could have asked for the contact information for the individual investors. They could have done. They could have followed up on that notice. I mean, your client undercuts the argument a little bit when they specifically say, "Hey, we're on notice here. We're concerned." I mean, that's not a quote, obviously, but we're concerned about this business structure. Give us more information.
Sure. Your Honor, I think two steps. One, that's really important to separate, and I appreciate the question, separating out into the two parts of the analysis. In terms of, to your point on inquiry notice and whether they were on notice, we respectfully submit they were not, given their understanding that there would be purchase loan mortgages, or in this instance, when Yates switched from what they thought it was going to be, they understood there were those. And in fact, the record demonstrates that other entities were also interested in the different properties. So the idea that there'd be another buyer. But Your Honor, for this morning's purposes, even if this court determines they were an inquiry notice, the most important problem, not for just this case, but from a doctrinal standpoint, if this court were to find that in this case with these fraudsters, once a party's on inquiry notice, it's an objective assessment. And U.S. Bank versus Villasenor, the Illinois Appellate Court, it's a 2012 First District case cited in our brief. It doesn't matter what Mr. Nambar did or didn't do on the second part. It's an objective assessment. And that's for good reason. Because no one's going to get off the hook here. Even if Shatar has priority, all of these arguments, they go to the fraudulent conveyance point and whether or not this specific party acted in good faith. And that has been stayed pending this priority determination. So I think it's very important. This court can require a district court for every future Illinois investor found on inquiry notice, setting aside Mr. Nambar and Shatar, to make sure that the actual facts matter as to what would have been found. And Your Honors, that's why the bonded financial case that is referenced in Brandt versus Horseshoe, the two cases we cite, and then the First Independence case in the Sixth Circuit really matter. This court in both those cases looked at the facts matter. In Bonded, when Bonded Financial sent the $200,000 transfer to European American Bank for Mr. Ryan, who ended up in prison because he was a fraudster, this court noted if European Bank would have called Bonded Financial, what would Bonded Financial have said? This is absolutely authorized. And we're not talking about...
But counsel, isn't there some evidence in the record that the 30B6, Mr. Nambar dropped the ball on some inquiries, that there was going to be a call, can you call me ASAP? And then the record's unclear as to what happened. To me, that shows a lack of diligence in following up on what were red flags.
Thank you for the question. Two points. One, I think actually Mr. Nambar testified credibly that 6 years, 7 months, and 16 days is when he was deposed. He was deposed on Halloween, that's what I remember. And he sent that email on March 15th. He said, I don't remember if we had the call or not. He didn't say, I'm not saying it didn't happen. He testified under oath he didn't remember. But Your Honor, most importantly, even if this court, for all those reasons, finds he was on inquiry notice, U.S. Bank versus Villasenor specifically says what the party did doesn't matter. It becomes about the objective. That is the crux of this case.
Mr. DeVoe, question about the Ponzi scheme presumption.
Yes, Your Honor.
District Court and Equity Bill 1 both agreed that the Cohens ran a Ponzi scheme and explained why. Why is that not enough to apply the Ponzi scheme presumption in this case?
Yes, Your Honor. I think for us it just boils down to a matter of 2 points. One, when you look at the Indiana transaction, it is the epitome of not, for what we know now, fraudulent conveyance discovery was stayed, but the money went from from Shatar to a third party to actually purchase the property. The receivership wouldn't even have the proceeds to distribute to anyone had Shatar not provided that money. But the real point, Your Honor, is that looking at, and I understand it's not controlling, but the district court case management in Utah, just talking about when you're at the priority stage and you're not at the fraudulent conveyance stage, just the notion of an individualized determination. And with that, Your Honors, I would respectfully request to reserve the balance of my time.
Very good. Thank you, Mr. DeVoe. The remainder of your time will be reserved. We'll now move to argument on behalf of the appellee from Mr. Stein.
Good morning. May it please the court. I'm Max Stein, one of the attorneys representing the certain individual investors. I am here once again representing a group of individual investors who made investments, usually from their retirement savings, with Equity Build, that Equity Build used to buy and rehabilitate properties in Chicago. Like the prior appeal in this case, involving the district court's rulings regarding priority, this appeal concerns which of two competing sets of priority claims will have higher priority. One, the claims of my clients and the other individual investors who had mortgages or were promised mortgages when they made their investments. And two, on the other hand, the claims of Shatar that it makes based on a loan it's made after one of the loans had closed from our investors' monies and that was used to refinance that loan and the purchase of the second property. While much of what has happened in the appeal before the court today is like what happened in the prior appeal, we recognize that that decision does not decide today's case. But, like the district court noted, quote, applying the law to a similar set of facts will garner a similar result. And we submit that's exactly what should happen here today. The facts here are similar, though different. First, the liens involved here are not simply mortgage liens. There is an equitable lien here. We submit that the district court appropriately and properly determined that the circumstances here justified entry or allowing of an equitable lien. And it is that lien that has priority over Shatar's claims. And second, the facts are different regarding the due diligence that was done by Shatar as the institutional lender. And that's because it's an entirely different institutional lender who did entirely different due diligence. But those differences don't change anything. In fact, as the court's questions have already noted, what Shatar did here was woefully insufficient due diligence. There's been a lot of focus on the question of inquiry notice. This is inquired notice. They knew everything, they asked the right questions, and they ignored the answers. Shatar is here today saying, speaking out of both sides of its mouth, by the way, it says, this isn't a Ponzi scheme for purposes of presumption. But you got to look at these people. They're fraudsters, clear fraudsters. And it says, these fraudsters would never have told us the truth. Well, the record reflects these fraudsters did tell them the truth.
Is it in the record that Namvar has been convicted of a Ponzi scheme?
Yes, Your Honor. That was part of the record submitted to the district court, and it's in our brief page 6 in a footnote. And that's also relevant, I would suggest, Your Honor. Shatar today says that setting aside Mr. Namvar and Shatar, and then says there's no facts that could have been determined through inquiry notice. Well, Shatar definitely wants to set aside what Shatar did here, because Shatar screwed this up. They asked the right questions, they got the answers that would have answered those questions, and they ignored them. Mr. Namvar testified that yes, he did ask for lots of information about their business model. What did Equity Build do? Did they lie and obfuscate? No. They sent him the documents that each one of my clients received and each one of my clients signed. Were they samples? Yes. Were they identical to what was actually provided? Also, yes. What did Shatar and Mr. Namvar do with that? Nothing. They ignored them. They did not read them. Mr. Namvar testified, why would I read them? I was going to use different loan documents. Well, that's an irrelevancy. The point here is, could Mr. Namvar and Shatar have known that there were existing loans and existing liens had it looked at those documents? The answer to that question is yes, it absolutely could have. And so what Shatar is trying to do is create a world in which what Shatar did doesn't matter. And instead, it should all be about what would a reasonable person learn. Well, a reasonable person would have learned exactly what Shatar could have learned. It just willfully chose not to learn it. The law has long held that you cannot be an ostrich. You cannot stick your head in the sand and expect to be okay. And that's exactly what happened here. In fact, if Shatar's arguments were accepted today, it would set a standard where you're better off doing worse due diligence. And that's because what Shatar argues is we're not like the people in Group 1 who relied on a fraudulent release. We never even asked for a release. And so we shouldn't be held to a standard where we would have gotten something that we would have relied on and been lied to. That makes no sense. That's the best way to end up with people doing little to no due diligence, which I would submit is exactly what Shatar did here, and then asking the courts to save them from their own mistakes. And because that's not the way the law is set up, and because that's not the way that the law is set up in equitable receiverships in particular, we would submit that the district court's opinion here should be affirmed. I want to touch on just one last thing, which is the standard of review here. This is an equitable receivership in which the challenge is not to any of the law that was applied here. Shatar's challenge today is really about how the facts get applied here. That is
Or how the law applies to the facts.
Thank you. I screwed that up. Thank you.
That's no problem.
That is subject to an abuse of discretion standard here. There is nothing close to evidence in the record of any abuse of discretion by the district court. To the contrary, every look at the record, every look at what Shatar actually did, confirms that the district court correctly held that the priority here should go to the individual investors and not to Shatar.
Mr. Stein, a question about appellate jurisdiction.
Sure.
And I'll be posing a similar question to Mr. DeVoe. We have Equity Bill 1. We've got the concurrence
Yes.
that raises this question. Waste management does not have or wealth management does not have a lengthy treatment of that question. This is a huge piece of litigation. We're on step 2 of what could end up being many steps, right? But it's always incumbent upon us to address that and look into that. Your thoughts on appellate jurisdiction?
So I'm going to leave most of this to Receivers Council, but I will observe from my perspective as an attorney representing a group of individuals who were the victims of a Ponzi scheme, that the idea that was adhered to in the first opinion in this case and that comes from wealth management is absolutely vital in a large case like this. Because what doing these appeals in sequence allows is when one of these groups is resolved and appealed and the appeal is resolved, the money gets distributed. If we were to instead wait until the very end of all of this, what we would be doing is effectively taking away from the district court one of its tools for effectively managing its docket and requiring the district court to get through all the way through everything before anything gets reviewed.
But efficiency can't overcome the rightness or wrongness of jurisdiction. So maybe you want to speak to that.
That's the point I'm going to leave
Okay,
to
very
Mr.
good.
Ratcliffe.
Thank you.
But I do want to emphasize the efficiency point because these are final decisions. I guess I will sort of answer your question, not just dodge it. These are final decisions because what would come from the adherence to the order that was entered by the district court is the distribution of the funds. And that order under wealth management does allow for appellate jurisdiction. And so we would submit that that's what should be followed again. And for all of the reasons I just mentioned regarding efficiency, including the fact that if you wait until the very end, so let's say the appeal of Group 1 had gone the other way, that would have informed the district court of the new rules of the road, which would then be applied to the rest of the receivership. It would be much more efficient for that to happen at the front end than for it to happen at the back end and have to go all the way back to the beginning and go through all 10 groups before you get to the end.
Thank you, Mr. Stein. We'll now move to argument on behalf of the appellee, Mr. Rachlis.
May it please the court, I'm Michael Rackless. Along with Jody Rosenwein, we represent the receiver in this action. My comments are going to be directed primarily to the issues, the narrow issues that have been raised as to the distribution plan that are part of Shatar's appeal, but I'll go directly to some of the questions that have been asked here, including, I'll start with appellate jurisdiction. We believe under 1291, the concurrence does affirm largely, it raises the question about which circuits deal with the questions of jurisdiction, but ultimately between wealth management and Equity Bill 1 provides we believe the proper jurisdictional basis for this appeal. The rights of each group have been completed at the time that the court has approved a distribution plan for these separate groups. That's what happened in Group 1. That's what's happened here in Group 2 as to the Shatar plaintiff. So we believe jurisdiction.
I understand the inertia argument, and certainly that was a concurrence, not a dissent,
Right.
in Equity Bill 1. But do you want to speak to whether this is a merits decision or not?
Well, ultimately, the ending of the groups does ultimately address the rights of those claimants. That is part of why this falls under the traditional collateral order doctrine type of case law. So I think that is true. The idea somehow, Your Honor, that there's going to be a flood of additional appeals, that is the concern, is not true here, in the sense that there is only one group left, and that is after the Shatar group, there's Group 10. The matters have been resolved in the district court level. So the one thing that remains outside of Group 2 and this one claimant in Group 2 is the unsecured claimant. So there will be a distribution plan for all unsecured creditors, and that is the last step for the case. So the idea somehow that there's been a lot of work before the district court on the other groups that have been identified. So the concerns that are raised about this being interlocutory, one, I believe that it is consistent with wealth management and Judge Easterbrook's concurrence in Equity Bill 1 and the jurisdictional basis for it, but two, the idea somehow that it's being undermined by a whole host of other appeals is not factually true given where we are in the district court. With regards to the Ponzi presumption, Judge Brennan, yeah, agree wholeheartedly that you've said it better than I could in terms of why the Ponzi presumption applies. Equity Bill, the district court's opinion in Equity Bill 1, this court's opinion and discussion of the Ponzi scheme fits squarely within the law on why you have the Ponzi presumption. If it's not applicable here, then you eliminate the Ponzi presumption at that point in time. Moreover, the court, as I just sort of talked about the jurisdictional bases here, the district court has applied that same type of analysis to the other groups in its resolution. That has also been true with respect to the netting rule and to their challenge as to the limitation on the recovery of principal. In Equity Bill 1, that was the appeal. That was the distribution plan included those elements. It was affirmed. Distributions occurred consistent with the affirmance of that distribution plan. The district court, in dealing with other plans, has applied precisely the same rules when dealing with those limitations, the application of the netting rule, the Ponzi presumption, and the issue of the return of the limitation on return of principal. So that same element here is not only have the court has done that as part of the EB1, but it's also consistent with the law in the Seventh Circuit. When you look at the appellant's position on this, they don't rely on Seventh Circuit authority. They don't look at wealth management. They don't look at the Central Sleep versus Duff decision. They don't look at EB in order to try and make their points as to why Seventh Circuit authority supports the lack of grounding that the district court had in its decision to limit the recovery to the principal invested, or in the application of the netting rule, when that is precisely, it fits squarely within that precedent that the court has done. Wealth management, the court there used equitable subordination in its discretion, the district court, to create a pro rata distribution plan, ultimately to create a class of claimants that had that were similarly situated in order to basically meet the standard of equality equals equity. In the Central Sleep case, there the district court created a pro rata plan expressly rejecting the application of interest, fees, penalties of that nature affirmed by this court. And of course, in Equity Bill 1, the exact same type of distribution plan with those limitations was before this court affirmed distributions occurred consistent with that plan. As a result, they have to go to the only place they can turn. They don't rely on Seventh Circuit authority. They have to go to the District Court of Utah for their only authority on these questions, which is neither presidential, as the court well knows, nor is it apposite here. If anything, if one looks, for example, the Jupiter case, which they rely on heavily, the court in that case actually used equitable principles to deny certain levels of interest that were being sought by the senior secured investors in that case. That was in a special master decision that was ultimately adopted by the district court there. So they don't rely on this court's authority when they go ahead and try and suggest that the distribution plan should be disturbed. As counsel indicated, abusive discretion standard applies in this case. There's been no evidence of an abuse of discretion. The findings of fact there's no record evidence to show that they're clearly erroneous or that there's no record upon which the courts have reached those rulings.
Thank you, Mr. Rachels. Thank you very much.
We ask for affirmance. Thank you.
Mr. DeVoe, we'll move back to you. We'll give you a little bit of extra time. We'll give you 7 minutes on rebuttal. And Mr. DeVoe, if you could fold in some comments on appellate jurisdiction.
Absolutely, Your Honor. Thank you very much for additional time. Just starting briefly, I think the most important takeaway from what we just heard from appellees is that there was no attempt to address what is the framework of the law on diligent inquiry. That the 2012 Illinois Appellate 120061, U.S. Bank versus Villarreal, we're not making this up. It's a two-step process. And the second step, for the sake of all future investors, is about, and it's an objective standard. And there was no attempt to address or defend the three suppositions from the district court on page 32 and 35. Your Honors, in fact, the only real defense or attempt to defend that is pointing to additional evidence, and that was Mr. Kermanian's deposition. But, Your Honors, on pages 30 and 31 of his deposition, Mr. Nambar explained that Mr. Kermanian was not someone he would have thought was an investor. Similarly, I don't want to waste the diligent inquiry point. We don't concede that, but it's not that nothing was done in this, and what they're trying to do is take this initial step and push it over, and if you think he's a bad guy, he was asked about his Ponzi scheme stuff at his deposition, Your Honor, that if you think he's a bad guy, you should just collapse the two steps. That's the crux of this case. They're still going to get their shot on fraudulent conveyance, but that second step for all future investors has to mean something, an objective standard. This court has said so in Bonded and in Brandt and First Independence for the Sixth Circuit. Obviously, Your Honor, you can have a fraud without it being a Ponzi scheme, obviously. And our only point on that is just for future individual determination. But the idea that we're talking out of both sides of our mouth, we're absolutely not. We would refer, Your Honors, to the SEC complaint, to the receiver's lawsuits. All of these, or this court's observations, all of these points demonstrate whatever one thinks about Mr. Namvar and wants to argue on fraudulent conveyance, on the objective standard, those 3 points, Equity Build was not going to give it up. And that's not me saying that. That's the SEC on the verge of collapse. They continue to lie to new investors. Your Honor, the last thing I want to say, though, on that point, on the steps they did take, just to show you how unique the situation is and that no objective inquiry would have found this, the law firm, and I hesitate, but Rock Fusco, the receiver sued Equity Bill's law firm, the very lawyer, when Shatar learned that Yates had been purchased. They asked, they didn't sit on their hands, they asked for the closing statement and the insurance document. And Your Honors, that's at 1537, page 250. And who was it that provided it? Equity Build's lawyers. The receiver's now suing them, accusing them, Your Honor, of, quote, for being intimately involved in creating the documentation necessary to advance Equity Build's various schemes. You have all of our contacts at Equity Builds and their lawyers, not us. The receiver, the appellee, has accused of committing and being a part of a fraud. Your Honor, to address the jurisdictional question, Your Honor, I do think that this court's analysis adopting the Fifth and Sixth Circuit that on the collateral order doctrine does apply. I do think that that's correct. I know that the concurrence raised that point. I agree with appellees. This is an important issue when you look at the factors. It is an issue that has been conclusively resolved. I think we come at it from different angles. From our perspective, we were very gratified the district court granted a stay for each of these as we appealed, because otherwise the funds, in fact, would dissipate, right, pending the appeal. In other words, if we didn't get to appeal till the end, but for that stay, we would have no chance of recovery. At least now on this appeal, we had this interim step. But I think that the 5th and 6th and 7th, I think it's the 9th that disagrees. I understand there's that split, but I think that this court got it right in its first opinion on footnote 2, saying that under established precedent that this court has jurisdiction. And lastly, it's really important to me that this notion of going after Mr. Namvar, I mean, first of all, he paid his debt to society, and it actually cuts against them. So he's supposedly this bad guy, this fraudster who knows all the angles in the Ponzi scheme. He himself got duped. These are his friends and family members that he brought their money into this. What incentive would he have? And that's setting aside reality just when it comes to Mr. Namvar. It's not fair if you want to talk about, this is a situation that applied to hundreds of investors, including their clients, including my client. If Mr. Namvar himself got duped, and it wasn't a matter of, he was given follow-up information. And it's not fair that when he under oath tells the truth, that he doesn't remember a conversation 6 years, 7 months, and 15 days. If we were in a trial downstairs and someone said they perfectly remembered a conversation, a good AUSA would chop them to pieces if they said they remembered having that conversation. And there's a reason for that. So I just ask your honors, if not for Mr. Namvar and Shatar, if for every investor in Illinois who in the future could be in a situation, yeah, they're on notice inquiry. But that means they're still entitled to an objective assessment based on the actual facts. And with that, your honors, respectfully request that this court reverse and remand. Thank you.
Thank you, Mr. DeVoe. Thank you, Mr. Stein. Thank you, Mr. Rachlis. The case will be taken under advisement. The court calls Appeal 24-3104, Soloway versus ALM Global and Guzman. We're going to begin with oral argument. Is Mr. Wiesel on behalf of the appellant?
Mr. Beisel, but
Beisel, thank
I
you,
won't hold
Mr.
that against you.
Thank you.
Good morning. May it please the court. My name is Patrick Beisel, and I represent the appellant, Mr. Soloway. And when a private individual pleads that a publication defamed him by accusing him of lacking ability in his profession and in his trade, what are the limits of Illinois' innocent construction rule? That's the central issue today. The innocent construction rule, as we know, can convert a statement that is defamatory per se into one that is not. But if, and only if, that innocent construction is reasonable. And that's the problem. That's where the district court erred. The district court granted ALM's motion to dismiss based on its application of the innocent construction rule. But the district court got it wrong. ALM's defamatory publications are incapable of a reasonable innocent construction. And there are 2 points that I want to make today in furtherance of that concept. First, this case can be reversed and remanded for the simple reason that ALM's publications, even when read in their entirety, constitute defamation per se, and there is no reasonable innocent construction that can save them. And 2, the per quote claim. The per quote claim was viable. Mr. Soloway didn't need to replead it. The district court wrongly applied Illinois law, and it shouldn't have been dismissed. Now, in 1982, there was a problem. Illinois courts were in disarray. The Supreme Court of Illinois stepped in Chapsky because previously, for decades, Illinois courts across the state had been straining to find unnatural, but possibly innocent meanings of words where such a construction was clearly unreasonable. And importantly, a defamatory meaning was far more probable. That's the case here. Now, we can examine the entire publication as I suggested. The only reasonable construction here is the one that we've offered. Mr. Soloway was fired from Cushman for his mishandling of Cushman's involvement in a Trump probe. That's the reasonable reading. That's what the reasonable reader understood. That's what ALM intended.
But counsel, is that the only reasonable reading? I mean, when a senior executive like this is let go, or there's a change in that level of leadership, you have an entire board that's addressing that situation. So why couldn't a reader come across this article and say, well, I don't know what happened here. I don't know what Mr. Soloway did or didn't do or knew or didn't know about the lawyers behind him, or if the court even got it right, because courts make mistakes sometimes, and here it was expunged. But what I do know is that the board came to a conclusion that they wanted a different lawyer.
No, Your Honor. I think that would be an unreasonable interpretation, and I'll explain why. I think primarily here, the rub is the phrase "in the wake of." The parties have gone to great lengths to explain this. Remember, we need to use the natural and obvious language. In the wake of is a journalistic turn of phrase. It's commonly used in this type of publication, which is a trade journal. In the wake of establishes a causal connection between two events, the triggering event and the thing that precedes, or succeeds rather, in the wake of that event.
Why is that? I don't see how that follows logically. There's a fallacy, post hoc ergo propter hoc.
Certainly.
It happens afterwards, therefore, the fallacy would be that it was the cause of.
Correct, yeah, and I'm not suggesting that that this is a correlation and now I'm arguing causation. I'm just looking at the words themselves. In the wake of. If I step out into a lake 8 months after a boat has passed, there's no wake. The time has passed. It cannot simply mean after in some generic temporal sense, as ALM and the district court suggest. It is a matter of consequence. It follows because of. And the district court, I'll point out, knew this. The district court defined in the wake of, in its opinion, as in the aftermath of, as a consequence of, or following directly on. And then the district court decided not to use those definitions. Instead, the district court simply said after. But that's not what in the wake of means, and that's not what was intended. What was intended here was to juxtapose the replacement of a high-profile GC with a rebuke in a Trump probe. This was sensationalism and clickbait, pure and simple. And the reason why they wanted to juxtapose those two things together with the phrase "in the wake of" was to make an insinuation, a connection, a causal link between his departure and a Trump probe, and to suggest that he was terminated.
Following up on that, is there any cases from our court or from Illinois courts that provide for an isolated reading of paywall information versus non-paywalled information?
No, Your Honor. This is a novel issue, as we briefed. I checked this morning. Nothing new has come to light. However, what I'll say is that this court has at times broached the issue but decided not to take it up. So, for example, in Juan v. Denton, the argument there was read the headline in isolation, ignore the rest of the context. This court said, I'm not going to do that because the context is right there. It's not hidden behind a paywall. It's immediately accessible. This is a very different situation, and one that no court in Illinois has squarely faced, and this court hasn't either. But the paywall issue isn't necessary to resolve this case. This case can be reversed and remanded when we consider the entire article. The entire article is defamatory per se. the context of the article that was locked behind the paywall is supposed to give, under Illinois law, the kind of salutary context that clarifies a potentially defamatory headline, that makes it clear what the headline really meant. But here it does nothing of the sort. In fact, it emphasizes and furthers the intended reading of the reasonable reader that Mr. Soloway was fired for his mishandling of Cushman's involvement in the Trump probe. And in terms of the reasonable reader, we have evidence of what reasonable readers believe in light of this article. And ALM has proffered no examples. Take, for example, Cushman itself. Cushman itself called ALM repeatedly after the April article was published and told them it was false. And then when ALM went directly to Cushman and asked them to comment, the response was, your story, and I'm quoting, suggesting a direct link between his departure and the contempt order is not accurate or factual. That's page 23 of the appellate record. So we know that a reasonable reader would construe this headline and the rest of the article the way that ALM intended, in a false way, in a way that ruined Mr. Soloway's life. And I want to be really clear about that, because there's been zero contention by ALM that he was in fact damaged in this way. He hasn't been able to get a job. He lost $2 million in salary. His entire professional reputation,
Actually,
30 years.
let me pick up on that. He lost $2 million in salary. Well, he voluntarily left Cushman, correct?
Certainly. He lost $2 million worth of earning power. There's ample reason to believe that he would have gotten the same or better salary at another position, given his impeccable record and over 30 years of experience. There's no reason to think that he couldn't obtain $2 million again. But instead, following this article, which has haunted him and refused to even get him in the door for an interview, he's been unable to get any jobs. And with that, I'll save the rest of my time for rebuttal.
Very good. Thank you, Mr. Bizel. We'll now move to argument on behalf of the appellee, Mr. Browning.
Good morning, Your Honors. May it please the Court. I'm John Browning of Davis Wright Tremaine, and I'm here on behalf of Respondents ALM Global LLC, the publisher of the New York Law Journal, Corporate Counsel, and its reporter, Hugo Guzman. The District Court correctly dismissed the two claims that are on appeal here. First, the defamation per se claim, which Mr. Soloway actually pleaded in his complaint, which fails under the Illinois Innocent Construction Rule, and the defamation per quad claim, which Mr. Soloway does not specifically plead in his complaint and declined to specifically plead when he had a chance to amend, which fails for that reason and the lack of special damages. Those decisions should be affirmed. On the standard for the Illinois Innocent Construction claim, I'd like to clarify a point Mr. Soloway's attorney made a moment ago. He suggested that what innocent construction means is that if a statement is capable of a non-defamatory reading and that interpretation is reasonable, that's the end of the conversation. It is not defamatory per se. Mr. Soloway referenced a slightly different standard, which might be that if one interpretation is far more reasonable than the other, there might be an issue that precludes dismissal, but that is not actually the standard and is a misstatement. If the Illinois law is very clear that if the two interpretations, one defamatory, one non-defamatory, are both reasonable, the non-defamatory interpretation controls. The court must dismiss. I just want to be clear on that point. So what is the non-defamatory interpretation here? As Judge Kolar, I think you said it better than I could myself. The non-defamatory interpretation is that Mr. Soloway, who's the general counsel at Cushman, at the time the company weathered a high-profile litigation involving its compliance with subpoenas in the Trump litigation, and then at some point after that litigation was resolved, he left the company. And here, I think I'd like to stress a tension in Mr. Soloway's argument. He tried to emphasize that he's looking at the article holistically, as he must under Illinois law. Illinois innocent construction rule is dependent on looking at articles in their entire context. As I'll go into later, the right approach here is to look at everything. But really, he also fixated on the headline, and specifically 3 words in the headline, "in the wake of." And that's not consistent with the innocent construction rule, which requires a more holistic approach and requires the court to look at the entire article. And on that point, I would like to stress some features of the article when it's looked at as a whole. Let's start with the headline and work our way down. The headline mentioned, the headline is, Cushman GC replaced in wake of company's rebuke in Trump probe. On page 53 of his brief, Mr. Soloway concedes that it is not defamatory to say that he was replaced. Rather, he stresses an alternative reading that the some headline in the article implies that he was replaced because of his mishandling of the subpoena proceedings. But that's not what the article actually says. The article simply says that he was replaced in the wake of the company's probe, and as your honors have indicated already, that is capable of a clear, reasonable, natural, non-defamatory meaning, as in he left the company after the probe and not because of it. Now,
To what extent could a publication describe parties subpoenaed in a case without losing the protection of the fair report privilege?
you know, I was thinking about this, or it's the innocent construction privilege. You said the fair report privilege.
Well, let's start with innocent construction, and then let's also talk about fair report.
So I think in innocent construction here, I think it's important to distinguish this case and these facts from a line of cases that Mr. Soloway relies on heavily, including Tweet. And I'm going to call those the sort of gratuitous innuendo cases. And in those cases, the context is very different. In Tweet, it was a mafia tell-all written by an admitted mobster about a lawyer taking $1 million in a sack of money to essentially settle a case. And there the court said it was unnatural to read this is a normal retainer and thus non-defamatory. Celaya is another good example. Celaya was a case where there was reporting about an antitrust civil action, and it included, and it was a civil action, and it included gratuitous detail, which is that under the Sherman Act, these acts could also be considered criminal. And actually, I think this crystallizes the answer to your question, Your Honor. A publication might be defamatory if it includes that kind of gratuitous detail, but that kind of gratuitous detail is not present here. Nowhere does the article state that Mr. Soloway's job performance was poor. To the contrary, it includes a quote from Cushman defending his handling of the matter, and the article makes clear that Cushman was ultimately vindicated. If you read the whole article, it says multiple times that the contempt order was overturned, the penalties were wiped out. They were given more time to respond. But just to make a hypothetical counterfactual, it might be different if the article included a gratuitous line along the lines of, normally in typical business, when a general counsel leaves a large corporation amicably, there is a statement about why he left. If you included that in conjunction with a statement saying Cushman did not explain his exit, perhaps there could be a defamatory innuendo, and that might be the limit of the innocent construction rule. But that is assuredly not what has happened here. What's happened here is, Your Honor, there's simply a gap. The facts which are accurately related are Mr. Cushman left, or Mr. Soloway left Cushman, he was replaced by a new GC, and his former employer didn't explain why, which leaves a gap raising questions about why, but the article does not improperly inject or suggest or implicate an answer to that question. And I think that helps explain the limits of the innocent construction rule and why it applies here. And I'd be happy to move on to fair report if you'd like.
Please.
So I think with respect to Mr. Soloway in the district court, there's been a bit of a misunderstanding about what respondents argued below here. This is an alternate argument, so this is assuming Your Honors disagree with me that my interpretation, the non-defamatory interpretation, is reasonable, and so the innocent construction rule doesn't apply. In the alternative, respondents do not, as the district court suggested, argue that every word of the article is simultaneously substantially true, a fair report, an opinion. And I will get to fair report in a minute, but I think it's important to stress this point. Rather, what we've argued, and what we argue now, is that those defenses apply to different parts of the article, and those parts combine to make a complete defense. So, moving to fair report to actually address the specific question, part of the article is a fair abridgment of the Cushman contempt proceedings. It notes that, just to summarize the summary, it notes that there was a contempt holding, but it also discloses clearly, multiple times, both in front of the paywall and behind it, that the contempt order was overturned by another court, and that the damages were wiped out. And I'm just going to backtrack in a second before Mr. Soloway attacks me on reply. The in front of and outside the paywall point, I think this is important. The record on, I think it's Appendix 43, shows a screenshot of what the second version of the article looks like to non-subscribers. And there are 3 bullet points under the What You Know section. And the last bullet point contains a very pithy one-sentence summary of what happens. Cushman was held in contempt. A later court overturned that holding. And so, just to sort of preempt this argument, from our position, it makes no difference whether you're looking at the paywall or not. As a matter of fact, looking behind the paywall or not, as a matter of fact, it's legally irrelevant as also.
Aware of any Illinois or Seventh Circuit cases on this distinction?
I am not, Your Honor. The parties have both cited a lot of Illinois and Seventh Circuit cases on the innocent construction rule in particular that emphasize reading articles and publications in their total context. The cases that hold otherwise are from courts or jurisdictions that don't recognize this rather unique rule, and so are irrelevant here. The cases are also factually irrelevant. So if you take Solano, which is the Ninth Circuit case, where the front page of a magazine indicated that a Baywatch star posed nude in one of the back pages, but if you went to the back pages, you would see that wasn't true. He was wearing his shorts. That case is very different from the case we have here. As I've said, Your Honor, here it makes no difference substantively whether you're looking in front of the paywall or behind the paywall. The gist of the article is the same on both sides, or at least the non-defamatory interpretation can be reasonably drawn on both sides. And so this really isn't a good case to get into whether there should be a distinction based on paywalls, even if the court wanted to take it up. And again, under actual Illinois and Seventh Circuit case law, there's a stress on reading things in context. So I mentioned the Tweet case before, which Mr. Soloway relies on heavily. There, the court read the entire book written by this mobster, and it held that, look, based on this context, this book is all about corruption. And so if you say a mob boss gave a lawyer $1 million in cash skimmed from a casino, you're going to assume that it's for a corrupt purpose, even if the article doesn't say so. And that really stresses the importance of reading everything. And here, I was thinking about this on the way over, and Mr. Soloway's insistence, or he's walked back on this in his argument a second ago, but in his briefs, his insistence that articles should be split so that the bit in front of the paywall and behind the paywall actually might work to disservice libel plaintiffs in future. Because this is a case where essentially Mr. Soloway is arguing respondents reported 2 independently non-defamatory facts, but in combination, those non-defamatory facts can be read together to create a defamatory implication. If Mr. Soloway is correct, and the paywall is a block between those 2 facts, and they must be read separately, it could create a situation where libel plaintiffs are in trouble. So imagine if in this case, the headline in front of the paywall simply said, Cushman replaces Soloway as GC. And then after that, after the paywall, it then had a report that didn't include that detail, but slated Cushman for its handling of the contempt proceedings. There would be no action. You'd have to read the 2 separately. The better rule is the rule that Illinois and the Seventh Circuit has recognized in the innocent construction context, in the historical context of newspapers, where a headline might appear in an article, and you'd have to buy it to read to the back, where the whole thing needs to be read together. And if the whole thing needs to be read together, Your Honors, respondents are confident that this article is capable of a reasonable, non-defamatory interpretation, and that requires dismissal of the per se claim. Moving to per quad briefly, I think there's 2 very important points to note here. The first one is Mr. Soloway's defamation per quad claims now are inconsistent with his actual pleadings.
We allow lawyers to argue in the alternative, though.
I'm happy to allow lawyers to argue in the alternative. I do it myself.
Right.
But I think there's an important point here that I still need to stress. The complaint doesn't mention the words per quad, which may be not fatal, but the thrust of the complaint and the thrust of Mr. Soloway's argument here is that the article is defamatory on its face. It's defamatory on its face because the implications that can be drawn from it fall into the per se categories for fitness and business. Now, defamation per quad comes in two flavors, but both are antithetical to these pleadings. So one kind of defamation per quad is when an article is not defamatory on its face, but you need to read in extrinsic facts. So an example of that, Mr. Soloway provided a helpful one. A newspaper reports a man burned down his barn. If people who knew him understood that he had an insurance policy on that barn, and that wasn't reported, that would be defamation per quad. So you read the extrinsic fact in with the reported one to get the defamatory implication. The other flavor is something that's defamatory on its face, but doesn't fall into one of the categories. We have neither here on the pleadings. Mr. Soloway is adamant that the article, particularly the words "in the wake of," necessarily imply that he was fired because of his handling of these proceedings, and that means that he has failed to plead either of the categories of per quad. And on this, I'd also like to note he had a chance when the court dismissed his per se claim to replead, that the court specifically allowed him to amend to make these claims better, or, as Your Honor said, to take an alternative tack and change course. He didn't. He doubled down. He's pleading per se, which fails under the innocent construction rule. Finally, on per quad, there's no dispute here. The per quad requires special damages. Special damages are realized, actualized, out-of-pocket losses. So if the article came out and Mr. Soloway lost a job that he had because of it, maybe that would be per quad, but that's not what he's arguing here. Here his attorney referenced his earning power, but his earning power is speculative. The fact whether or not he could get another job paying $2 million a year, which sounds really nice, is conjecture, which is not, but is not special damages. And finally, Your Honors, I think we actually omitted this case by mistake. Mr. Soloway says he lost interest from recruiters because of the article. That's not special damages. The Kapotsis case we quote, but I don't think we pull out this exact quote, makes that point. It's not special damages as a matter of law. It's all he's pled for special damages, and the per quad claim must be dismissed, or the dismissal must be affirmed. Unless Your Honors have any other questions, I'll rest on my papers.
Thank you, Mr. Browning. Mr. Bizel will now move to you for rebuttal argument.
Thank you, Your Honor. I have 4 points in rebuttal. I'd like to pick up where we just left off with per quod. So there's a couple of points that need to be clarified here. The rule as articulated by opposing counsel is not quite right. So it's true that there are two flavors of per quod. One, the classic one, where you need extrinsic evidence to establish the defamation, because defamation per quod quite literally translates to with explanation. The second flavor, though, it's not quite right. So the second type of per quod is where you don't need extrinsic evidence because the statement is facially defamatory.
How does that differ from per se?
It differs from per se in the sense that the defamation per se statement at issue is deemed cured by the innocent construction rule. But the innocent construction rule doesn't apply to per quod. So if it's saved by the innocent construction rule, you still have per quod as a backstop for facially derogatory remarks that impugn someone's profession. That's exactly what happened here. It's facially defamatory. The only reason why we get past per se at the district court level is because of the wrong application of innocent construction. So if we assume that it is innocently construed here, then we have a facially defamatory statement. It cannot be cured anymore by the innocent construction rule, and per quod applies. So here, extrinsic evidence wasn't required. And even if it was, I contend that we had sufficient extrinsic evidence demonstrating that this was in fact defamatory and that people understood it to be defamatory. And as to special damages,
So why didn't you replead then?
why didn't we replead?
Yeah, why didn't you replead?
Candidly, Your Honor, we didn't think that it was necessary. We pled sufficient extrinsic evidence in the complaint itself, and under the law, we don't need to plead extrinsic evidence. The only thing that we need to plead are special damages. And here, the special damages are just the $2 million. We're not saying that the inability to get a job is the damage. It's the $2 million. And the $2
But
million.
how do you link that under Illinois law? I'm forgetting the name of the case, but it's the case where the person had a really great, was the lead candidate on Wednesday, and there was a defamatory statement on Thursday, and then the company said, you're out. And that, I think the Illinois Supreme Court said, was not enough for special damages. So how explain to me why you think your situation is different and what law you have to support that.
Sure. So I would point to Imperial Apparel. In that case, the Illinois court explained quite succinctly that you only need to put the other party on notice of the damages that you're claiming, which here are pecuniary as the law requires, the $2 million. And importantly, the plaintiff
But
is...
what about a headhunter case? Because we're downstream, right, from an actual, even a job offer. Is there any case law supporting special damages when a headhunter lost interest in the candidate?
I'm not aware of a specific case with a headhunter losing interest, but I don't think that that is the case here. Yes, there are 2 executive recruiters who refused to associate with Mr. Soloway after the publications, and there was a job offer nearly on the table that was taken away because of the article. Those are the 3 examples that we did plead. So it's a little bit more than that. But again, we're not...
This is the Zoom. There wasn't an offer there in that situation, was there?
There was not an explicit offer, no. There was intimation that he was a great candidate, that he would be fast-tracked, that he would get the job promptly following that interview. Step into the interview, it's going wonderfully. She asks about online presence. As we've articulated, Mr. Soloway has none. The only online presence that he has are these defamatory publications. So she goes online, and then he hears back 3 weeks later with an automatic rejection. Like, the reason there has to be and can only be that it's because of these publications. I want to make sure that I get to a couple other points since I'm low on time. So the notion that these 2 reasonable interpretations can't be balanced together. Sure, if they're both reasonable. The Illinois Supreme Court has been very clear that there is no balancing if they're on the same footing, but they're not on the same footing here. The innocent construction that was applied was not reasonable, and the defamatory one is more probable, and that's the rule from Chapsky. And I would point out that even this court recently in Giant Screen pointed to that same example and used a more reasonable standard. So if the defamatory statement is more reasonable, then the defamatory one wins out. So courts in Illinois, in this court, do in fact balance interpretations. Balancing is accepted. It's only when they're on equal footing that the innocent one wins out. As to the defenses, I just want to make clear that is not before this court. That was not a basis for the motion to dismiss. So we do not need to cover substantial truth, fair reporting privilege, or opinion. The only defense that's before this court is the affirmative defense, meaning it's their burden to prove the innocent construction rule. And as to those defenses, I want to point out sort of the irony of opposing counsel discussing how the defenses work when you split up the article. You split it into pieces, and one defense goes here and one defense goes there, rather than reading it as a whole. And we were taken to task for the exact same thing with the paywall, where we are asking the court to read the headline in isolation, the body separately. So it cannot be both. And as to the paywall, my final point, I will just say that I don't think that if this court or if Illinois courts had a paywall type rule, that it would be negatively affect libel plaintiffs. I think that it would be an egregious loophole for publishers who could simply put the most sensationalized headlines that they wanted with impunity and then put curative information behind the paywall. Patrick Beisel's a murderer. Just kidding.
Thank you, Mr. Beisel. Thank you, Mr. Browning. The case will be taken under advisement. We'll move now to appeal 24-2649 Chicago Teachers Union, local number 1 et al. Versus Educators for Excellence Incorporated. And Mr. is it Gahagan? We'll go with you first.
Gagan, Your Honor.
Gagan, thank you. We'll go with you first.
My name is Tom Gagan, and good morning, Your Honor. And I am representing the appellant, Chicago Teachers Union, and Moselene Parker. May it please the court. When someone violates federal law, there should be some way of holding that person liable. That's the gist of our appeal here. And under this court's decision in Local 150 versus Ward, where this court implied a legal remedy on behalf of the union to enforce Title V of the LMRDA, likewise, this court, under the same logic, should imply a remedy for the union to enforce Title IV of the LMRDA, or one specific provision. And that provision is Section 401G of the LMRDA, which is a prohibition against employers from helping union officer candidates in an election, from subverting the election, from providing aid, from recruiting candidates to run in that election. The defendant in this case, we alleged in a pre-election suit, was violating that prohibition.
Is the question whether or not there is an implied cause of action a jurisdictional question or a merits question?
It is a merits question because there's unquestionably federal question jurisdiction here. And the issue is whether there is a cause of action, not whether there is jurisdiction. And the district court properly found that there was jurisdiction, subject matter jurisdiction over the issue, but found no cause of action. And the reason there is a cause of action, an implied cause of action, under the logic of Local 150, is that without a remedy, the employer faces no consequences for violating the law. There is no express remedy that the union has, that the member has, that even the Secretary of Labor has against the employer. This is a situation that I respectfully submit may have no parallel in federal law, where an entity faces a federal prohibition and can violate it without any consequence at all. And worse than having no consequence at all, if the employer violates it to the degree that it affects the outcome of the union officer election, then the Secretary of Labor brings a suit against the union, not the employer. In fact, has no jurisdiction to stop the employer from violating the law again. In this case, the logic of Local 150 calls out for the same kind of implied remedy that this circuit decided existed to enforce Title V, maybe even more so here. While this is a regulatory prohibition, and I'm going here into the logic of Local 150, which says if there's a right, there should be a remedy. While this is a regulatory prohibition, and Title IV is really a series of regulatory prohibitions against certain types of conduct, it is also an affirmative right of the member, not just a regulatory prohibition against an entity, but it has a counterpart, usually in Title I of the LMRDA. That's what the Supreme Court decided in Crowley versus Local 82. It has a counterpart in Title I, which is why many of the regulatory prohibitions in Title IV, not all of them, but many of them, can be enforced pre-election under Title I as violations of an affirmative right that belongs to the member. And what is that affirmative right? It's an affirmative right for which the entire statute, LMRDA exists. It is to confer upon members of unions the right to have democratic control of their union, to have leaders that are accountable to them and not beholden to outside interests, because union membership is not just some nominal right or even a civic right, it's an economic right. It is a right of great economic value to the membership, and it should be protected by democratic means. So, for that reason, the union member in Crowley versus Local 82 was deemed to have a Title I right to enforce what the court said is, in effect, a 401G prohibition. And the court made clear in Crowley why it was doing it.
Mr. Kagan, as I understand it, Section 42A1 requires exhaustion of remedies.
That's correct.
Did the union exhaust its remedies here?
Well, it requires exhaustion of remedies when a member is seeking to challenge the outcome of an election. And in the case in the case here where the member was suing and the CTU was suing both as an institution and as an association of its members, there wasn't any remedy to exhaust because the union has no power to stop the employer from interfering in its affairs. In every other case, you're correct, Judge, the union member should exhaust remedies because in 90% of the issues that come up during an election, it's the union's conduct that is at issue. So you go to the union first to determine whether the union will correct its own conduct. But here the union did nothing. In fact, the union is the victim. And that's what's so pernicious here, that the union, both as an association of its members representing its members' rights, and as an institution that has an obligation to its members to provide them a fair election, the union has no express remedy unless one is implied. And there's no way really to make the LMRDA work without this implied remedy. And while that might seem an extraordinary statement, it's become commonplace in judicial decisions, especially including in this circuit, and beginning with Crowley, to say that the LMRDA is a very poorly drafted statute, that Title I was added on the floor, that it's hard to make sense of what is Title I and what is Title IV, and there has to be a certain amount of judicial work that has to be done. And there has been judicial work that has been done, and Crowley is very significant in doing a lot of that work. And Crowley's holding is that there's an overlap between Title IV and Title I. Now, it's true that there's no express Title I remedy against an employer, which is exactly why we're here to say that under the logic of Local 150, there should be an implied remedy. The same interplay between the prohibition and the right that justifies pre-election suits to enforce regulatory prohibitions in effect, as Crowley said, should apply here.
But counsel, where's your argument that this is what Congress intended, that Congress intended to create a private right, even if the statute isn't a model of clarity? That's what we need to look at. I mean, the days of there's a right, so we need to, as a court, ensure there's a remedy. I don't think that's good case law anymore, right? Now we're instructed that we need to determine whether or not Congress intended to create that private right. And here, in 41C, Congress is pretty clear. Whatever we want to agree about the rest of this statute, 41C is pretty clear. You have a right of action. You can come to federal court. And here, there is no right of action, at least that's expressly provided for. So where do you get the reading that Congress intended the private right of action?
In this way, that if you look, Your Honor correctly pointed out that 401C or 481C, I suppose we should say, creates an express right of action. And there is no other express right of action on Title IV. But Crowley has held that in effect, because Title I and Title IV have to be resolved together, there are really rights of action to enforce the 401G prohibitions pre-election. And let me just make this point, which is that in every other case, you name the violation, there is a remedy by the member ultimately. So, except for employer violations, that is, you can either have a pre-election suit under Title I, which is what the Supreme Court held that the statute does provide, or you can go to the secretary to have the secretary come after the violator, which is always the union. There's this only one area, this tiny piece of it, where there's no remedy at all. And given the nature of the right that is given to the member to have the right to vote, it's appropriate under the same logic as Local 150 to imply remedy here. Or put another way, at a minimum, Congress could not have possibly intended that the union will be held liable for a violation by the employer without the union having any power to save itself from that. Congress could not have intended that. Now, how do we know that? Is that just a conjuring? The Supreme Court in Sadlowski versus Steelworkers pointed out that there's the strongest congressional policy against employers from coming in and interfering in union officer elections. Sadlowski is eloquent on that point, and it is also in federal law in other ways. So Section 302 of Taft-Hartley prohibits an employer from paying off a union officer. Section 882 of the National Labor Relations prohibits employers from dominating a union. And other provisions of federal law, racketeering acts and other ways, are all aimed at stopping employers from subverting unions. So if there's ever a congressional policy that is as clear as daylight, it is that employers should not be violating, should not be trying to interfere in union officer elections.
Would you like to reserve the remainder of your time for rebuttal?
I will reserve the rest of my time.
Very good. Thank you, Mr. Gagan. Mr. Martin will now move to you for argument on behalf of the appellee.
Good morning. May it please the court. I'm Josh Martin for the appellees. In the nearly 7 decades since the LMRDA was enacted, no court has held Section 481G to create a private right of action. As this court has long recognized, an implied remedy exists only where there is a persuasive evidence that Congress intended to create one, and any inquiry into congressional intent must begin with the language of the statute itself. Here, the statutory text demonstrates in at least 4 ways that Congress did not intend to create a private right of action under Section 481G. First, Title IV contains an express remedy for violations of Section 481 in Section 482, which the statute explicitly says in Section 483 is an exclusive remedy. Second, that express remedy calls for enforcement by a public official, which courts typically recognize as precluding an implied cause of action. Third, a different subparagraph of Section 481, Section 481C, also contains an express remedy for certain violations, undermining any inference that Congress intended to create an implicit remedy in Section 481G. And fourth, other portions of the LMRDA, specifically Title I and Title IV, also create express causes of action for union members to bring suit and for certain violations, further demonstrating that when Congress intended to create a remedy, it did so expressly, not by implication.
Mr. Martin, a similar question as I posed to Mr. Gagan is whether the union has an implied cause of action a jurisdictional question or a merits question.
We agree that it's a merits question here for the same reasons said by opposing counsel.
Thank you. The union also alleges that there will be a violation of the act at some point in the future. Is there any kind of a ripeness problem here?
We think that this is really a post-election challenge related to the 2022 union election. In the intervening time, there's been a second, 2025 union election, which again, they do not challenge the outcome of the election itself, and there's been no, allegations of wrongdoing that we're aware of in this case or in any other case. So to the extent that this is looking for a permanent injunction against an employer for all potential future involvement, we don't understand why they're singling out our client, and we think that this would open the floodgates to allege that any employer has recruited or provided monetary support for a candidate in violation of 481G and get into federal court for pre-election purposes, kind of per se.
You're not disputing that your client is an employer under the act, then?
We're not disputing that it's an employer under the act, under the broad definition of employer, but I don't think that is dispositive in this case. To the extent that I was going to address legislative history, but we broadly, didn't come up in the first half of this argument. But if all that textual evidence were not enough, the legislative history confirms that Congress struck a careful balance of rights and remedies in Title IV and did not invite courts to police union elections except on narrow and expressly enumerated circumstances, far from the powerful showing of congressional intent necessary to substantiate an implied private right of action. The available evidence here points firmly in the opposite direction. Subject to the court's questions, I'd like to walk briefly through each of these textual indications and also briefly explain why state law does not provide a cause of action here either. The enforcement mechanism for Section 481, including 481G, is set out in Section 482, which provides that a union member who has taken steps to exhaust available remedies under union bylaws, which CTU has not done here, or the individual union member, may file a complaint with the Secretary of Labor to allege the violation of any provision of Section 481. The Secretary may then investigate the complaint, and if she finds probable cause to believe that a violation of Section 481 has occurred and has not been remedied, they may bring a civil action against the labor organization, including intervening to oversee a new election. And Section 483 states that the remedy provided by this subchapter for challenging an election already conducted shall be exclusive. Reading that text, it is clear that Congress intended Section 482 to be the exclusive federal remedy. That is to say that the remedy provided within this subchapter, Title IV, which challenges an election already conducted, describing Section 482, is exclusive for enforcement by this subchapter. The statute in Section 483 even says that existing rights and remedies to enforce the Constitution and bylaws of a labor union with respect to elections prior to the conduct thereof shall not be affected by the provisions of this subchapter. Shall not be affected means that the text makes clear that Congress did not intend to create any additional rights and remedies, such as the private right to suit, under Title IV beyond what was already existing prior to the enactment of the LMRDA. So based on the plain reading of the LMRDA, courts have agreed that there is no private cause of action under Title IV because Title IV may only be enforced by the Secretary of Labor. And that goes all the way back to the Supreme Court case Calhoun v. Harvey in 1964, which stated Section 402 of Title IV sets up an exclusive method for protecting Title IV rights by permitting an individual member to file a complaint with the Secretary of Labor challenging the validity of any election because of violations of Title IV. Calhoun v. Harvey itself was a pre-election case asking for an injunction, which is what opposing counsel alleges they're asking for here. And courts have followed suit, including the Seventh Circuit in Kempthorne versus United Transportation Union in 1972 and Driscoll versus International Union in 1973, both of which also sought pre-election injunctions. And in Driscoll, it states, "We are bound by Calhoun v. Harvey, which itself was a pre-election case and which impliedly required that the election first be held before any Title IV remedies be made available to the plaintiffs." Other circuits have followed suit. In this case, this court has held the remedy of Section 482 to be exclusive as recently as 2010 in Corner versus Solis. The Supreme Court in Alexander v. Sandoval has suggested that when there's an express enforcement provision, that suggests that Congress intended to preclude other remedies, such as implied causes of action. And courts typically take a statutory provision for enforcement by a public official as implying that no other means of enforcement was intended. For example, this court ruled in Stewart v. Parkview Hospital in 2019 that the sole remedy for a HIPAA violation was to be brought by the Secretary of Health and Human Services because that statute, HIPAA, included an express remedy and denied a private cause of action.
What about Mr. Gagan's argument here that this would be a violation without consequence? It would be with impunity if there is no remedy here.
We think that there are plenty of adequate remedies outside of a private cause of action here, namely, especially because of, we think that Section 482 provides an adequate remedy, but specifically that exhausting internal remedies would have been able to provide a adequate remedy here, which CTU did not do here. So for example, we, in our brief, cite CTU's bylaws that were active during the 2022 election, and those remedies include those bylaws include a prohibition on contributions from all non-members, which would include E4E, and then there are election protests under Section 18 of those bylaws, and it says that the protest to the eligibility or non-eligibility of any nominated candidate under these rules can be filed within 2 calendar days of the announcement of candidates, or if they wanted to protest the election results themselves, any protest to the conduct of the election or any candidate's conduct during the election period under these rules must be filed in writing within 5 calendar days of the announcement of election results. And then, under the same Section 18, subletter D, it says the Rules Election Committee shall issue its written decisions regarding the challenge or protest no later than 10 calendar days after its receipt of the challenge or protest. So in theory, if a candidate they believe that they're running against, if you're the plaintiff here, the individual plaintiff, you believe is being funded by an outsider, they could have filed a protest 2 days after their nomination or within 5 days of the election results being certified and gotten an election result returned by their own union board within 10 calendar days, in theory having a result within 15 days of their complaint. And then if they weren't satisfied by that result, they could have brought an action to the Secretary of Labor under Section 482. And the Secretary of Labor could have rerun the election, or because to point out the protest about the suit being against the union, if the union wanted to have a voluntary compliance agreement with the Secretary of Labor, they wouldn't have to be in district court at all. They could avoid that process, and the Secretary of Labor could rerun an election without the violating conduct, as long as the Secretary of Labor found the investigation that there was a probable cause that the statute was violated such that it affected the outcome of an election. So that is my response on why there were adequate remedies here. And in theory, because E4E is an employer, the Secretary of Labor may be able to bring an action against E4E. We have not seen an example of that case in the past, but in theory, they're governed by the Secretary of Labor and under Title IV of the LMRDA as well. So additionally, there are another subletter, as mentioned in your question earlier, Judge Kohler, and Section 481C that has an express cause of action under a different subletter of the same section of the statute, which also implies that the Congress could have written an express remedy if they had wanted to. Likewise, Title I, Section 412, and Title V, Section 501 of the LMRDA both provide causes of action for their titles of the statute, and there is no such blanket private right of action under Title IV. And there is a Title IV case, McBride versus Rockefeller Family Foundation in the Second Circuit, which explicitly disposed of a Section 481G claim for want of a private cause of action. So instead, opposing counsel relies on Crowley, to say that Title I and Title IV rights overlap, because you can't find, there's no Title IV case on point here which authorizes a private suit. But in fact, if you read appellant's opening briefs at page 10, when analyzing Crowley, they themselves write that while the Secretary of Labor exclusively enforces Title IV, and they themselves write, the Secretary of Labor exclusively enforces Title IV, there's nothing in the legislative history suggesting Congress intended to foreclose all access to federal courts under Title I during an election, but we're not here to litigate Title I, we're here to litigate Title IV. And Crowley remains good law, it just doesn't grant the appellants the relief they request here, where they are asking the court to grant a private right of action under Title IV. Likewise, they mentioned Sadlowski as evidence of congressional intent, that there should be no outsider involvement in elections, and we agree that the Congress intended to limit outsider involvement in elections based on this 481G that we're talking about now. But Sadlowski is Title I case and it's inapplicable, and what it really stands for is that unions should be able to create reasonable rules that are rationally related to a legitimate purpose to govern their own affairs, which is what they can do here and what they should have done by enforcing their own bylaws to disqualify candidates who they believe are impermissibly taking benefits from an employer in violation of Section 481G and their own bylaws. And Ward is just simply a different case because it's Title V has an express remedy, and they in the court in Ward essentially extended that express remedy to unions themselves instead of union members. And there in Ward, if you read Ward, you'll see that there's a circuit split, and the Supreme Court had failed to resolve the issue of whether a union could bring a private suit under Title V. And here there's really just no circuit split. We have Calhoun v. Harvey saying that there's no private right of action under Title IV way back in 1964, and every circuit has followed suit since. With only 1 minute left, I want to make sure that I address state law remedies, and there just simply isn't an Illinois cause of action here because there's no statute granting a right of action. There's not a clearly ascertainable right independent from the LMRDA. And there's not a Van Dale style cause of action here. Opposing counsel doesn't identify an Illinois statute that provides a cause of action. Instead, they merely cite language that injunctions will be granted when there are clearly ascertainable rights in need of protection, which is just part of a 4-part test that applies to injunctions in Illinois law. And it requires a likelihood of success on the merits. Well, if the merits are dependent on the LMRDA's Section 481G, then it's really not. We're not getting to the merits. Then they also cite Van Dale, which is an Illinois Supreme Court case from 1972, but they severely overstate Van Dale's holding. Courts over and over again in Illinois, and I'm sorry about my time, have held Van Dale to stand for the limited proposition that courts will only intervene in voluntary organizations when plaintiffs have been stripped of substantial economic benefits without due process, such as the expulsion action, where plaintiffs demonstrate indicia of bias in the expulsion process. You can see a number of cases in our brief that discuss that. Thank you.
Thank you, Mr. Martin. Mr. Gagan, we'll go back to you now for rebuttal. We'll give you 3 minutes on rebuttal.
Thank you, Judge. First, I want to correct a statement of my brother counsel here. CTU and Mosley and Parker are not challenging the conduct of an election. So we are not within the framework of 483, which says that challenging the conduct of an election or challenging an election already conducted is exclusively the province of the Secretary. We completely agree with that. And this is a pre-election suit. And it is a pre-election suit that is implicitly blessed in the legislative history to the extent that the legislative history confirms that Congress really did not want the Secretary to interfere in union affairs except to the extent necessary. And a pre-election suit allows the union to ensure that there is a lawful election that doesn't require the Secretary's intervention. Aside from the legislative history, Senator Kennedy said explicitly that Section 483 does not bar pre-election state remedies. Archibald Cox, who drafted this statute, says it does not bar pre-election state remedies. And Clyde Summers, who was also involved in the drafting, very prominent professor at the, who was in labor affairs and involved in the drafting, wrote that it does not bar pre-election remedies. I want to address this issue that there is an express remedy under 481C, and therefore nothing should be applied otherwise. First of all, that was not the case in Local 150. There is an express remedy for union members to sue for breach of fiduciary duty, but the court found, this circuit found, that in context and given congressional intent, there should be a remedy applied even though there was an express remedy for breach of fiduciary duty in the statute. So under the same logic, that should apply here. But also to discuss something important about 481C, it's unlike anything else. It is a right of the member to have the union conduct a mailing, and on the candidate's behalf, it has to be in there because it's an affirmative act. What we are seeking, and what all these Title I suits are about, which are enforcing Title IV prohibitions, are going in for negative prohibitory injunctive relief. 481C has to be in there as a pre-election right because the remedy is a lot of affirmative relief of a very unusual kind. You know, the right to conduct a mailing, the right to see the membership list, the right to be there when the mailing goes out. Of course, that has to be spelled out in some detail. But in this case, all we're seeking is just an injunction that says, stop. And a court should be more ready to apply such a remedy in that situation than, and not use the elaborate kind of affirmative relief that is set up for a very specific purpose under LMRDA to make the union elections viable at all, because if you don't have literature out, you can't really have the election. So I don't think it's fair to say that the pre-election remedy, this very extraordinary affirmative pre-election remedy, implies that there's no right to have what is, just simple equity, which is just stop violating the statute. That's all that we're seeking here. And it's also the case that I see that my time is up.
Thank you, Mr. Gagan. Thank you, Mr. Martin. The case will be taken under advisement. We're going to move now to Appeal 24-1914. This is United States versus Taylor. And we'll begin with our oral argument on behalf of the appellant, Mr. Hessler.
May it please the court, my name is Daniel Hessler. I represent Andre Taylor. I will start with a cross-reference. The issue is with the findings that were made, could the uncharged murder on September 2nd be considered relevant conduct to the charged gun possession on September 19th? The cross-reference from 2K2.1 and its notes tell us that earlier crimes can be considered relevant conduct to later gun possession only if the defendant used or possessed the charged firearm in the previous offense. In this case, the only findings that were made were that Mr. Taylor culpably participated in a murder on September 2nd, that he knew firearms would be involved generally, and that someone used the charged Glock. The district court decided this qualified as using or possessing that particular Glock because it concluded that anyone who participated on September 2nd was responsible for any guns used, and the September 19th Glock was one of those guns. One of the problems with that reasoning is that it involves using relevant conduct principles in multiple steps in an odd order. The examples used in application note 14 all implicitly involve a first finding that the defendant possessed the charged firearm on a previous occasion, then a finding that he committed some crime with that firearm, which would make him accountable for the previous crime in his present case because they're part of the same course of conduct. Again, here the district court first found that Mr. Taylor participated in the previous crime, then went the other direction, used aiding and abetting liability to hold him accountable for the charged block, despite the absence of any evidence of use or possession, then used that accountability to make the murder part of the same conduct as the later gun possession. The text of the cross-reference requires a finding of use or possession to get from one offense to the other. It's important to remember that the reach of legal accountability is broader than what is considered use or possession. Let me give you an example. Let's use a hypothetical, somebody who helps out a drug dealer. Steve's a lookout. His job is to keep an eye on a stash house that he doesn't have the keys to. Is he guilty of participating in the drug crime? Of course he is. If he knowingly participated and tried to make the crime succeed, he's guilty on an aiding and abetting basis. Now, what if he said, I never possessed those drugs, and the jury believed him? Would that make him not guilty? It wouldn't. Possession isn't required. You can have accountability without possession. Let's go back to the cross-reference. 2K2.1 requires that the defendant used or possessed a charged firearm in the other offense in order for that offense to become relevant conduct to a later gun possession charge. That choice of language is a deliberate choice for the Sentencing Commission to narrow the reach of relevant conduct principles. This is also consistent with the language from the enacting commentary to Note 14E, which describe the relevant conduct rules as one restriction on the reach of the cross-reference, and Note 14E as a further restriction. That same enacting commentary mentioned a reason for this, being that the cross-reference can expose a defendant to the highest level of any crime he may have committed. In other words, they were worried about exactly this situation. And all of this is consistent with the examples the parties have tossed back and forth, both in the district court and the briefs here. We looked at the weapons enhancements in the drug guideline, 2D1.1B1, where there's a two-level enhancement if a dangerous weapon, I'm quoting, if a dangerous weapon, including a firearm, was possessed. The Sentencing Commission there used the passive voice, signaling accountability that would occur regardless of who did the possessing.
But counsel, can't this possession be constructive possession? And why wouldn't the district court's findings on, I believe it was the September 2nd, the date of the murder, why wouldn't that amount to constructive possession of the weapon?
Constructive possession is defined as knowingly having the power and intention at a given time to exercise dominion or control over an object. I'm just taking that out of the circuit's jury instructions. Of knowledge that somebody else was going to use a firearm without any evidence of a particular firearm, a specific one, doesn't mean that Andre Taylor had any control over that Glock on September 2nd. There's no evidence that he ever touched that Glock until September 19th, the 20 seconds that we know about. So constructive possession doesn't get you anywhere. Again, I was going back to the idea of, the enhancement in the drug guidelines, uses a passive voice construction to say it's broad accountability. And in contrast, the safety valve provision of 2D1.1B18 They word it, it says if the defendant can be eligible for the safety valve reduction if the defendant did not possess a firearm or other dangerous weapon, or induce another participant to do so in connection with the offense. And this court's case law says that Pinkerton liability doesn't apply to that one, and the reason is because of the wording that the Sentencing Commission chose.
Mr. Hessler, time is short, and I did want to touch on the reckless endangerment question.
Sure.
If you don't mind. How attenuated does the presence of the police and third parties need to be to avoid creating reckless endangerment?
I think it is a factual question, as this court has said in things like United States versus Lard. But again, there has to be something. Here, there was no pursuit. There was no he was never seen with a gun. No one was around when he tossed it. It landed in a very isolated spot, and the gun had safety features designed to keep it from going off.
But he didn't know any of that.
Well, there was no evidence that he. There was no evidence. Actually, there's no evidence that he did or didn't. And it's the government's burden on that. Arguably, he did know that he was alone in the street.
As I read Judge Tharp's sentencing transcript, he goes into quite a bit of detail with regard to findings of fact on this particular section, correct?
He does, and if you're asking about the fact that he didn't know,
yeah, yes.
I would describe that as error because it's saying the defendant didn't prove that it didn't apply. It wasn't the defendant's burden to prove anything.
And you were present at the sentencing hearing, so
yeah,
you heard it all happen.
I was counsel.
All right, thank you. Would you like to reserve the remainder of your time?
Yes.
Very good. Thank you, Mr. Hessler. We'll now move to the argument on behalf of the appellee, Mr. Zenner.
May it please the court. I'm Eli Zenner, and I'm arguing on behalf of the United States. I'd like to start with the cross-reference. Judge Tharp correctly applied the cross-reference based on the language in 2K 2.1c and the relevant conduct language that's in the application note, or that's incorporated by the application note.
What's the limit to that? When would a defendant's conduct be sufficiently separated from accomplice or acting and abetting liability to avoid being implicated in those acts?
I think on that you look to the relevant conduct guidelines, and I would note in the application note there's a subsection B, I believe, is the scope. And it talks about some of the outer limits, and really the question is what's reasonably foreseeable? Was this joint criminal activity? Did the defendant know what was going to happen, what the plan was? And was it reasonably foreseeable that, for this case, guns would be used? Here, Judge Tharp correctly found that it was reasonably foreseeable that guns would be used. Some of the language he used at the sentencing was that this was premeditated, pre-planned, and it was inconceivable that anyone who was in those two cars would not know that guns were going to be used to commit this murder. And that's the reason that he found that Andre Taylor, the defendant, was liable under agency principles for using and possessing the Glock and the other guns used. And it's because it was reasonably foreseeable to him that guns were going to be used. The evidence presented at sentencing showed that they drove around for 25 minutes hunting for their victim. The evidence showed that they stopped in tandem with two cars, and 3 men got out and gunned down the victim. Everyone in those two cars knew that guns were going to be used. It wasn't a surprise. And so when Mr. Taylor was caught with that same gun a little over 2 weeks later and charged with possessing that gun, it was reasonable to hold him accountable via the cross-reference for using that gun in a murder. And I think Mr. Hessler misunderstands the application note, which is entirely focused on it being the same gun. The changes after 2002 to this cross-reference and to the application note are entirely focused on it being the same gun. It doesn't deal with the agency principles in relevant conduct. It makes clear that the gun in the charge offense has to be the same gun in the cross-reference offense. And we have that here. The Glock that Mr. Taylor was caught with is the same Glock that was used to murder Kadavion Jones. Mr. Hessler also claims, and he makes this argument of the active and passive voice, and it focused on the distinction. Some of the guidelines enhancements say, defendant possessed a gun. Some say a gun was possessed. But the relevant conduct language makes clear that agency principles are appropriate for the cross-reference at issue here. And I'd also note that one of the enhancements that actually has the passive voice, that's 2D 1.1B12. That's a drug enhancement for maintaining a stash house. That has active voice. It says, it has passive voice. Let me get my active passive correct. So that has active voice. It says defendant maintained a stash house. But I would note that case law that this court has issued, that's triplet, actually holds defendants liable based on agency theories for maintaining a stash house. And that specific argument that defendants making about this distinction between passive and active voice was actually rejected by the Sixth Circuit in the Rich case that we cited in our brief. In that case, defendant made the same argument regarding the stash house enhancement. He said this has active voice. It says the defendant has to maintain a stash house. You can't hold him accountable based on agency principles, and the court rejected that. It said we look to relevant conduct, and relevant conduct allows for agency liability, and that's appropriate here. And I think the case law we cited shows that courts regularly apply enhancements based on agency liability. They regularly apply gun enhancements under 2D 1.1, 2B 3.1, and in the Aduwo case that we cited, which is under the 11th Circuit, they applied the cross-reference that's directly at issue here to a defendant who did not actually possess the gun, but engaged in joint criminal activity, there a robbery, and her co-conspirator had a gun. That's the same thing that happened here. Mr. Taylor knew that guns were going to be possessed. He engaged in a joint criminal undertaking, the murder of Jones, and he knew the guns were going to be used, and he's accountable for those guns. So the cross-reference was correctly applied here based on Judge Tharp's findings at the sentencing. I next want to turn to the reckless endangerment. Again, the facts here were that came out at sentencing were very clear. Defendant ran when he saw police. He was carrying a gun when he ran. He tossed that gun over a high fence from which you couldn't see to the other side. And he did all those things recklessly. The court's finding on that enhancement was correct, and it's well supported by Seventh Circuit case law, specifically the Brooks case. In Brooks, the defendant ran from police. It wasn't clear that police could actually see the gun when he pulled it out, but he was clearly running from police. And he dropped that gun in a residential area. Here, Mr. Taylor threw the gun over a fence into a residential backyard. And I think a lot of those videos were submitted to the court. It was clear that that residence was occupied. It was a backyard that had patio furniture. It was a busy street. And within seconds, neighbors and the occupants of that house had come out of the house, and they're the ones that had provided the video that led to Mr. Taylor being arrested. So I take issue with Mr. Hessler's claim that there weren't people around or that someone couldn't have been hurt. When you run from police with a gun in a crowded residential neighborhood and throw it, you are reckless, and you are endangering human life. That gun could have discharged, a child could have found it, or police could have seen him with the gun. And as Your Honor said, Mr. Taylor did not know whether police could see him or not. He didn't know who was in that yard, and he didn't know whether the gun was going to discharge. And that's textbook reckless behavior. The final thing I would say is that regardless of whether the technical guidelines applications were correct, Judge Tharp's sentence was reasonable. And any error he made in applying those guidelines was harmless, and he made that clear in his sentencing. He stated that even if he had made error on the specific guidelines at issue, Mr. Taylor's involvement in the murder was so dangerous that it warranted the sentence that Judge Tharp ultimately gave. It's very similar to the Snyder case that we cited, where the district court inoculated his sentence by explaining that the dangerousness of the defendant's involvement in a murder warranted a significant sentence regardless of the guidelines. The same result governs here if the court determines that the guidelines were not appropriately applied. Thank you.
Thank you, Mr. Zenner. We'll now move back, Mr. Hessler, to you for rebuttal argument.
The government starts their discussion of the cross-reference with and sticks with simply the discussion of the relevant conduct guideline, 1B1.3. I suggest you have to start from the 2K2.1 and the cross-reference in its language and the note that it's got, because the note and its enacting talent commentary say it was written to address the controversy about what the reach of the cross-reference was. And so just going to relevant conduct principles in general doesn't get you there. You have to go through that first. And then the government starts talking about it being reasonably foreseeable that anybody who was involved in the murder would have known about guns. We agree with that. And if we were starting from this being a murder charge, then the fact that the guns were reasonably foreseeable would make anybody involved accountable for any gun. However, if you look at the relevant conduct guideline, it says the reasonable foreseeability language says, in the case of a jointly undertaken criminal activity, things that are done by multiple people. The murder may have been done by multiple people, but what Mr. Taylor was charged and convicted of and pled guilty to was gun possession on September 19th. That was a one-person thing. There was nobody else charged. There was nobody else alleged in any of this to have had that gun. In fact, the government kind of fought that in the district court.
Thank you, Mr. Hessler. Thank you. And thank you, Mr. Zenner. The case will be taken under advisement.
Thank you.
We'll now move to Appeal 23-1201. This is Singh versus Bondi. And we'll begin with oral argument first from Mr. Budzinski.
Good morning, Your Honors. Budzinski for Petitioner Singh. There's one issue today, and it concerns the term employment in 8 U.S.C. sections 1255C and K. These sections prohibit adjustment of status to permanent residency if an applicant engages in unauthorized employment exceeding 180 days. The length of time is not an issue here. The period exceeded 180 days, but below, the agency concluded that Singh engaged in unauthorized employment and denied his application to adjust status. Singh is a Sikh priest. He entered on an R1 visa. The petitioner for the visa was a temple in Wisconsin, and that temple sent him to perform his religious duties at other temples. The Sikh temple in Wisconsin, however, continued to pay his wages, although the temples that he was sent to provided room and board. Below, the agency concluded that this constituted unauthorized employment. The regulations at 8 CFR 274A1 H, F, and G define the terms employment, employee, and employer, and they require the provision of services for wages or other remuneration. Similarly, the board in Hall used the phrase in return for. From this, we can conclude that we are looking for a quid pro quo. That is the performance of the duties in exchange for wages or other remuneration.
Is the challenge that's being made to the IJ's finding that receiving food and lodging constitute compensation, isn't that a challenge to a factual finding?
I don't think so, Your Honor. So I think the underlying facts here are undisputed, and what we're doing is applying those facts, or applying the law to those facts and determining whether this is employment.
We only have jurisdiction to review challenges on legal questions, constitutional questions. What is your best argument to say that the challenge that's been brought here by this petitioner is in that bin?
So first, I think one of the questions we're asking is, what is the meaning of the word employment in the statute? And I think that's a purely legal question. Additionally, I don't think we're challenging any of the factual findings. I think they're undisputed. And in that sense, we have an application of the law to the facts that's a mixed question, and that's still reviewable under Wilkinson. Here we're looking at just other remuneration as the Wisconsin Temple continued to pay Singh's wages.
Wilkinson is in the context of cancellation of removal. Is there a certain authority that you're pointing to for a standard review for us for adjustment of status context?
So in Wilkinson, they told us that mixed questions are reviewable as questions of law. It falls within that term. Questions of law are generally reviewed de novo, and we would ask the court to review this issue de novo. There is, of course, respondents' argument that deference needs to be given here, and they're asking for substantial evidence review. But because we can't review the underlying facts, only the application of law to those facts, I think it's already inherently deferential, and de novo review would be appropriate. The agency concluded that the other remuneration that Singh received was the room and board. This room and board falls short of the full support provided in Hall. Hall was also provided clothing, medical expenses, transportation, entertainment, toiletries, and other personal expenses. Singh was not. And on top of this, the Sikh temples offered the meals and lodging to anyone who was in need. Something that's free and available to other people who need it is not remuneration. That is something that would not attract and keep employees, as it would be available without regard to whether the person was performing any services. A similar concept comes up in taxation. Meals and lodgings furnished for the convenience of the employer. 26 U.S.C. Section 119 excludes such meals and lodging from an employee's gross income. And this is premised on being provided for the convenience of the employer as opposed to in exchange for the employee's services. So even if the room and board here were not already offered free, it would be offered for the convenience of the temple, as Singh's religious duties began at 2:30 in the morning and continued throughout the day. In such circumstances, there's no quid pro quo. The room and board is being offered for the convenience of the temple or the benefit of the temple, not in exchange for its services. Additionally, the temple in Wisconsin controlled Singh's work and his wages. Only that temple paid his wages. He was not free to go to other temples. He was not free to refuse these assignments. He could have been fired. He also maintained contact with the Wisconsin temple. If Singh wanted a raise, he would contact the Wisconsin temple. If there were any complaints about his service, the Wisconsin temple would be contacted. And under these circumstances, the employer-employee relationship was only to the Wisconsin temple. Respondent addresses the merits here, and I've largely addressed our arguments, but there's a couple other things we should discuss as well. First, respondent argues that Singh testified that the Bakersfield Temple did not provide lodging to others. I don't believe that's accurate. I don't think it was particularly addressed specifically, but Singh explained that it is a tenet of the Sikh faith that all temples provide a place to rest. Respondent argues that Singh received special lodging. I don't think that's supported by the record as well. He stayed in a separate room, but there's nothing to distinguish his room from a room that he would have received had he not been providing the services. Respondent also argues that the temples could dismiss Singh and therefore control his employment. However, this is not being able to fire him or control his employment, because even if the services were no longer needed at the temple, he would still have his employment with the Wisconsin temple. Respondent also discusses the use of temples using various employer ID numbers. I don't think this matters at all because we're looking for the quid pro quo. We would ask that the court reverse and remand this case. Employment requires a quid pro quo, and the one doesn't exist here except to the Wisconsin temple. And if there are no other further questions, I'll reserve the remainder of my time.
Thank you, Mr. Budzinski. We'll move now to Ms. Groff for you for argument on behalf of the appellee. I should say, the appellee.
Good morning, Your Honors, and may it please the Court, Stephanie Groff for the Attorney General. Your Honors, this Court should dismiss Mr. Singh's petition for review, as this Court lacks jurisdiction to review the agency's determination that he did not merit a grant of adjustment of status. Specifically, Mr. Singh seeks to avoid the statutory jurisdictional hurdle by framing his challenges to the agency's denial as a legal question of what constitutes employment. However, at bottom, he is challenging the immigration judge's specific factual findings relating to lodging, food, and who had control over his work, which the board appropriately reviewed the immigration judge's findings for clear error, indicating that these are factual findings. Because it is a disputed factual finding, this court lacks jurisdiction pursuant to 1252. To answer one of Judge Brennan's questions posed to my friend on the other side, looking at Wilkinson is appropriate here because 1252 A2B notes cancellation of removal as one of the relief that the circuit court cannot look at, and in that it also states adjustment of status. So it lists various forms of relief that are discretionary, then it cites to A2D, which says that it needs to be constitutional questions or questions of law. And so while Wilkinson specifically was addressing cancellation or removal, the respondent argued in its brief and in our recent supplemental authorities that this court can look to Wilkinson and the recent decision in this court in Santos to indicate whether you have jurisdiction or not.
Is that dicta or holding?
The Wilkinson?
The particular point that you're making about the inclusion of adjustment of status.
It is part of Wilkinson. It specifically is talking about cancellation of removal and the application of law to fact, but those premises can be directly applied. We are arguing and is not dicta. While this court, I noted that we filed a recent supplemental authority in Santos, but while that case dealt with cancellation of removal, this court can look at it for the same premise that disputed facts are still unreviewable, and that's what we have here. Importantly, while my friend on the other side just listed various facts that the respondent pointed to that he disagrees, those specific ones constitute disputed facts, and therefore this court cannot look at it, specifically as it relates to the lodging and the food provided. As Mr. Singh's counsel noted, he was petitioned through U.S. Citizenship and Immigration Service to work at a Sikh temple in Wisconsin. While there is no dispute that he never worked there, in the record, the immigration judge made factual findings that the food and lodging that he received from the 3 other temples that he worked for were given for his services, meaning that he was outside of the scope of what his original visa was for. Additionally, the control. My friend on the other side claims that that's not an issue here, but who had control over him is a factual finding that cannot be reviewed because it is disputed. In fact, the immigration judge found that it was not clear that the Wisconsin temple had control over him. Mr. Singh testified and noted before the board in his appeal that the other temples had the ability to possibly let him go if his services fell below a certain standard. He even testified before the immigration judge that the different temples told him what to do on a day-to-day basis. These findings are factual findings that are disputed, and we argue that the court cannot review them. Now, if this court were to disagree with us as it relates to whether these are disputed or not, even assuming that they're not in dispute, and this court were to assume jurisdiction, that's where our alternative argument relating to Wilkinson and reviewing a mixed question comes in. The government believes that this mixed question, so undisputed facts, applying the law to that, should be reviewed under substantial evidence standard of review. And in this court's recent decision I've mentioned in Santos Mendoza that was recently published, while this court did not decide whether for cancellation or removal it should be reviewed under clear error or substantial evidence, we argued in our brief and today that substantial evidence is the more appropriate standard. While there is very minimal difference between these, and we're getting really into the nitty-gritty of it, substantial evidence is the standard review utilized in immigration and APA proceedings when looking at immigration judges' factual findings, and so we would ask the court to follow that. Under substantial evidence standard or clear error standard, here the record supports the agency's finding. I'll note that my friend on the other side asked that this court review it de novo, but in Santos Mendoza, this court specifically rejected for cancellation reviewing it de novo. It talked about Wilkinson and how it noted that when there are undisputed facts, applying it to the law and whether it meets, it's clear from Wilkinson that it needs to be some discretion to the agency, to the finding, and therefore de novo is not the appropriate standard. And we would reiterate that finding that de novo is not appropriate here, but under de novo, under clear error, under substantial evidence, which we ask, the record firmly supports the agency's decision. And let me just specifically turn to our argument that petitioner on his appeal to this court waived various factual findings that are dispositive. Specifically, the agency found that there was nothing to indicate that the Wisconsin temple informed USCIS that he would be loaned out to other temples, therefore exceeding the scope of his employment. He was petitioned on a temporary non-immigrant worker visa to work at the Wisconsin temple. By admitting that they did not tell the USCIS that he would go to other temples, the immigration judge took issue with that and found that demonstrated that this was unauthorized employment. In addition, the board held that on appeal, he noted that the various temples had different IDs, employment IDs for USCIS, which indicate that they themselves would be able to petition for him if they wanted him to work, which is also demonstrated by the fact that the Greenwood Temple eventually did petition for a non-immigrant visa, and ultimately what we have here, the permanent immigrant visa. These factual findings were not addressed before this court and therefore waived, and they are at issue because it specifically supports the agency's finding. So if you reach that, we would argue that substantial evidence, in addition to the other findings, support what we have here. And if there are no further questions.
Very good.
Yes, thank you so much.
Thank you, Ms. Groff. Mr. Budzinski, we'll go back to you now for rebuttal argument.
Respondent argued that the immigration judge's conclusion that room and board was given for his services is a finding of fact. I don't see that. I view that as a conclusion of law that goes to the very legal conclusion whether this was an employment relationship, whether there was a quid pro quo at all. This isn't a finding of fact. This is a conclusion of law based on the circumstances that were testified to, the circumstances that are in the evidentiary record. Whether this existed is whether employment existed at all. And if there are no further questions.
Thank you. Thank you, Mr. Budzinski. Thank you, Ms. Groff. The case will be taken under advisement. We'll now move to Appeal 24-1674, Bolden versus Pesavento et al. And we'll begin, Ms. Barnea, with oral argument from you.
May it please the court. A jury awarded Mr. Bolden $25 million for past and future physical, mental, and emotional pain and suffering and loss of a normal life. This appeal concerns the prejudgment interest that the district court added to that sum. The prejudgment interest award should be reversed for two reasons. First, as a matter of law, prejudgment interest should not be available for non-economic damages. And second, granting prejudgment interest was an abuse of discretion under the circumstances here.
As I understand it, Ms. Barnea, the city's position is that the fact that Hillier is an admiralty case is not dispositive. Is that correct? You're asking for us to vacate Hillier, reverse Hillier.
That is correct. That's not our only argument, but we do think that Hillier should be overruled because it does not confront the tension between prejudgment interest and non-economic damages. Those two things are not compatible, and that's true across all areas of law, admiralty, section 1983, in any context. When prejudgment interest is appropriate when the damages are economic, because economic damages give the plaintiff his money back, money that was spent, money that was taken, money that should have been earned. That money would have been in a bank account, it would have been earning interest, so a jury's award gives a plaintiff his money back, and then the district court, in its discretion, steps into the shoes of the bank and adds interest, and then the plaintiff is made whole.
I have to ask this next question delicately. Sure. It's only being asked because you do represent a municipal party.
Yes.
And if the question puts you in an awkward position, you prefer not to answer it, you certainly have that right, all right? The parties apparently have agreed that if prejudgment interest was properly awarded, that Bolden will accept a reduced amount. The agreement is not an ECF. The parties indicate that it can be provided to the court upon request. Do you want to speak to that at all, or would you prefer not to? And that latter does remain an option for you.
Sure. The number that we've agreed to as the reduced amount is not in the record, as you say. I'm willing to provide it right now, or I can provide it in a supplemental letter. It is a meaningful amount of money to the city. We are a municipal defendant with limited financial resources, and we work with taxpayer money.
I think it's a very fine answer. Thank you.
So non-economic damages function entirely differently from economic damages. A plaintiff who suffered intangible harms has lost well-being, and there's no precise dollar amount that can fully reverse the plaintiff's injuries. So the money is a rough proxy for what the plaintiff lost. On a practical level, it makes no sense to apply a rate of return to non-economic damages because emotional well-being, if the plaintiff had kept it, can't be invested in a bank account and earn interest. And emotional damages don't accrue evenly with set starting and ending points. Juries also implicitly factor in the time that a plaintiff has waited for the judgment. So compensation for the wait is baked into the award, and the awards are entered in present-day dollars. So there's no gap for prejudgment interest to fill. When prejudgment interest is added to non-economic damages, it becomes a penalty payment for unsuccessful defendants. And that's because with economic damages, a defendant knows the range of money that's at stake at the outset. And as the Milwaukee Cheese case states, a defendant can invest that money during the litigation and then use the proceeds from the interest to satisfy a prejudgment interest obligation. So because of that dynamic, when economic damages are at stake, prejudgment interest isn't punitive.
What about this concept of it being a presumptively available, prejudgment interest being presumptively available to victims of a federal law violation?
Sure. So all those cases that say that were in the context of economic damages. And for the reasons I've described, that makes complete sense because the defendant knows it's not a penalty in that context. The defendant knows at least the range of money that it's on the hook for. But with non-economic damages, those are highly subjective. They're unknown until the jury renders its verdict. They cannot be approximated in advance.
What about the idea that you roll the dice if you want to go to trial and prejudgment interest incentivizes parties to settle, right? This is a wrongful incarceration case. There's lots of data out there on what juries are giving. So what do you say to that?
So because the compensation in a non-economic damages case is baked into the award, there's already an incentive to move things along because a plaintiff who's been a jury is going to know that the plaintiff's been waiting, and that compensation for the wait is going to be included in the award. Also, defendants should not be penalized for deciding to go to trial. That's something that defendants are entitled to do, and having prejudgment interest available for non-economic damage also provides an incentive for plaintiffs not to settle, knowing that if they go to trial, there's another additional payment that could be coming, especially if it takes a long time. And I'm not suggesting that that occurred in this case. I'm just talking as a matter, broadly speaking, as a matter of law. So prejudgment interest on non-economic damages is functionally a penalty, and there are numerous cases in the circuit that say that prejudgment interest should not be used as a penalty.
Counsel, one of your strongest arguments that I'm hearing here is, well, it's the prejudgment interest is kind of baked into what the jury is considering. But you made that argument below, and there could have been pretty explicit jury instructions taking that option away from the jury. It's a little muddled here, and Judge Seeger made his decision and his findings. I don't know that we can say in every case that the prejudgment interest is baked into the jury's award just because we're dealing with non-economic damages. But if you want to address that a little bit more, go ahead.
Sure. In this case, it was clear that it was baked into the award, and that would be true for a case that's asking for past and future compensation, asking for full compensation. There's no specific number that was given, and there's every indication that the award here covered the full range, including any suffering that Mr. Bolden experienced between when his claim accrued and the judgment. Broadly speaking, as I mentioned, juries tend to, cases say that recognize that juries implicitly bake into the award the time that a plaintiff has had to wait. So it is true, broadly speaking, that this is included. And prejudgment interest for non-economic damage, prejudgment interest is supposed to compensate for the loss of use of money. But in a non-economic damages case, There's no claim for the loss of use of money. That plaintiff has lost well-being, so it doesn't serve the same, prejudgment interest doesn't serve the same purpose as it does for economic damages. There's no market adjustment that needs to be done. And it's applying a formula to an intangible harm doesn't make practical sense. It's demanding things of non-economic damages that just aren't true. They don't accrue on set starting and ending dates. They amorphously aggregate over time. So it's not a good fit for the prejudgment interest formula. It just doesn't make sense. We do have arguments in our brief about why the award was an abuse of discretion here. I want to be mindful of my time, so I'll reserve the rest for rebuttal.
Very good. Thank you, Ms. Burnham. We'll move Mr. Litoff to you now for oral argument on behalf of the appellee.
Good morning. May
Morning.
it please the court. Eli Lidoff on behalf of the appellee, Mr. Bolden. It has been the law of this circuit for 40 years that prejudgment interest is presumptively available to victims of federal law violations.
And I understand you've got a waiver argument with regard to that being cabined to the Admiralty situation, meaning that the city's not arguing that Hellier is limited to Admiralty. The challenge that we face as a court in resolving the case is we've got a 1984 decision, and then we've got a lot of district court decisions, but nothing recent. And what we do have quite a while ago is something that seemed to be in a different context. Do you want to speak to the state of our law and why we should recognize prejudgment interest in the non-economic?
Yes, Your Honor. So Hillier was an Admiralty case, but its reasoning was based on the concept of making the plaintiff whole and providing full compensation, something that is impossible without accounting for the time value of money. That is the same logic that courts apply in all other contexts, including in 1983 cases. And I think it's also important to note that to do what the appellants are asking you to do here would not only be to overturn Hillier and declare that prejudgment interest is categorically unavailable for pain and suffering, but it would also be to split with the 1st, 2nd, 5th, 6th, 9th, and 11th circuits, all of which have applied prejudgment interest to pain and suffering damages and have held that that's appropriate. There's no reason to do that here. I think the discussion of whether prejudgment interest should be awarded for pain and suffering damages has to be grounded in the purposes that prejudgment interest is intended to serve, and there are two dual purposes. It is to compensate the plaintiff for the loss of use of money between the time the claim accrued and the time of the judgment, and it is also to disincentivize delays by defendants and prevent unjust enrichment. Neither of those purposes are impacted by the nature of the injury, and the prejudgment award and interest award in this case served both of those purposes. Starting with compensating plaintiff for the time value of money. There is no dispute that Mr. Bolden's claim accrued on April 19th, 2016, when he was exonerated and released from prison. There's no dispute that he promptly and diligently pursued his claims, and there's no dispute that because of the way our legal system operates, it took him over 6 years to get to judgment, to obtain that compensation to which he was entitled. And he is entitled to compensation for that 6-year wait.
Let me press you on that a little bit. Non-economic damages, emotional, mental, not a usually liquidable figure. If one is to offer prejudgment interest in a civil case, in a trial court, you'd have to have an expert witness to talk about the time value of that money. Very difficult to connect time value as a concept with a non-liquidable amount. You see the dilemma?
I do, Your Honor, and the courts over the years have sort of departed from that hard and fast rule of whether it's liquidated or unliquidated damages being dispositive. I think what's important is that, you know, the Imoko Cadiz case, for example, from this court says it might take time for the victim to obtain the judgment, but once there is a judgment, the obligation is dated from the time of the injury. And this is not, I think one thing that's important to be clear about is this is not about giving him interest for the 22 years he was suffering in prison. That's not what this is about. This is about granting him interest for the 6 years after his claim accrued, when he was pursuing his claims and awaiting his judgment. It's not about compensating him for those decades behind bars. It's about the 6 years that he was waiting. And that is a compensable amount, regardless of the nature of the injury. In addition to providing full compensation, the second important purpose of prejudgment interest is, to deter delays, to disincentivize delays, essentially to act as a general deterrent. And without prejudgment interest, defendants have incentive to delay. They have incentive to hold the money that might be used to compensate the plaintiff, to earn interest on it, and then to use that interest to satisfy the ultimate damages award and reduce their out-of-pocket expense. And this general deterrence purpose is served, again, regardless of the injury. During the entire time this case was pending, those whole 6+ years, the city had the benefit of that money that it was holding and not Mr. Bolden. It's true that in a case with pain and suffering damages, the defendant doesn't know exactly how much might be due to the plaintiff as compensation, but that's true in many cases. In a contract case, damages are disputed, right? You never know with certainty how much is going to be awarded until you get the jury verdict. The fact that they didn't know if it was going to be $25 million, $10 million, $15 million, it doesn't matter. They held that money and had the benefit of it, earned interest on it during that 6-year period. And that, the case law has said, is essentially unjust enrichment if we allow them to benefit from the time value of that money. That is in the Rivera case from this court that talks about that we have to not only fully compensate victims, but also prevent unjust enrichment. And also in the matter of Milwaukee Cheese case that my opposing counsel cited, they said that's why an interest award, no matter how large, can't be punitive. The defendants can invest those funds while the litigation proceeds and then use the interest to satisfy the obligation. So, because pain and suffering damages are not categorically excluded from a prejudgment interest award, the only question is whether the district court abused its discretion in determining that prejudgment interest was appropriate here, and the court did not. The city argues that the jury intended to make Mr. Bolden whole, that the juries, factor in the weight. That is complete speculation. Judge Kolar, you hit on this point. The city made that argument below. They said this was already baked in, the award fully compensated the plaintiff, and Judge Seeger reviewed the record, looked at the jury instructions, looked at the trial transcript, looked at the closing arguments, and found that the jury compensated Mr. Bolden for his incarceration, not for the time value of money since then. That's at pages 3 and 4 of the opinion. That is a reasonable exercise of the court's discretion. The only question here is whether no reasonable court could have found that, right? And it's impossible to say that based on this record. It's also a reasonable exercise of the court's discretion because in the Seventh Circuit, as the court found, it's the court's job to award prejudgment interest, not the jury's job. And so to speculate that the jury took this into account when there's no mention in the trial record of the time value of money, of interest rates, it would be speculation, and it was certainly not an abuse of discretion for the court to find that the jury did not intend to compensate Mr. Bolden for the time value of money. In that same vein, the city says that the award compensated for future damages, which are not eligible for prejudgment interest. Again, that is an argument that was made below. It was briefed extensively. There were arguments about why the entire award was for past damages. There were even alternative calculations proposed by Mr. Bolden that said, if Your Honor agrees with that some future damages are baked in, here's an alternative calculation. You can say $22 million was for past damages for the 22 years incarcerated, and you can
Counsel,
take $3
but
million.
Judge Seeger didn't actually address that argument. So this is a challenge that I have with the order. that the past future, it might have been argued extensively, but where is it in his order specifically that?
It's at pages 3 and 4, Your Honor, where the court conducted a careful review of the record. It says, reviewed the transcripts from closing arguments in which counsel asked for compensation for Mr. Bolden's incarceration and determined, quote, the jury had awarded damages for the 22 years that Bolden spent in prison. That was the finding, and it was supported by the record. And again, this is in our briefing below at docket number 695, where we grappled with this issue. And what was clear is that 22 years and the notion of compensating Mr. Bolden on a year-by-year basis was the center of the trial. During closing arguments, this is part of what Judge Seeger examined when he said he looked at the closing transcripts. Plaintiff's counsel said, what you're going to have to do is decide on what is the value of a year of a man's life, asking the jury to award $1 to $2 million per year that he was incarcerated. Defense counsel spoke in terms of years as well, saying Mr. Bolden was seeking $1 to $2 million per year, and therefore he has 22 million reasons to lie to you. He wants $22 million. The jury was asked to compensate Mr. Bolden, I see him out of time, to compensate him based on years incarcerated. Judge Seeger looked at the record, determined that's what the jury did. You can't say that no reasonable judge would reach that conclusion.
I actually have a follow-up, if I may.
Sure.
So what do I do about these jury instructions that say you will fairly compensate plaintiff for any injury that you find he sustained and is reasonably certain to sustain in the future? And there's other references to the future. What do we do with those jury instructions?
The jury absolutely was permitted to award damages for future pain and suffering. And if Judge Seeger, examining the record, had said, based on these instructions, based on the testimony, based on closing arguments, I have to conclude that some portion of the award was for future damages, that would have been in the court's discretion as well. But the jury did not have to award compensation for future damages. The jury was free to say, he was incarcerated for 22 years. This is how much that's worth. We're not giving him anything.
I guess we don't know because the verdict form just has a single line, right? So one can assume that most of that was for incarceration. 22 years is not a small amount of time, but there's a fuzziness there, right? And this was an agreed verdict form, is that correct?
That is correct.
Okay.
That is correct. And there's a fuzziness there, no doubt about it, and that's why it's committed to the discretion of the district court, who by the way, was extremely attentive during trial, who was engaged in all of the witness testimony, who was hearing the arguments presented, to look at it and make the determination within his discretion that the jury was asked to award compensation for the years he spent in prison, and that is what they did. And again, Your Honor, it would have been, if Judge Seeger would have said, I think X was for the past suffering, but the jury had to factor in, some amount for future, that would have been within his discretion as well. But what the city is asking this court to do is essentially substitute its view of the record for that of the trial judge, and that's not appropriate here.
Very good. Thank you, Mr. Litoff.
Thank you.
Ms. Barnea, we'll go back to you now for rebuttal argument.
I want to address a few points that opposing counsel raised. We explained in our brief why Hillier should respectfully be overruled. Hillier did not, as I mentioned, confront any of these tensions that we've been discussing, neither do the cases it relies on. And as to the point that we had Mr. Bolden's money during the wait, the city defendants did not take one penny of Mr. Bolden's money. This was not a case about a loss of money. Defendants did not know the amount of money that was at stake. There was no way that the defendants could have held it. Mr. Bolden asked for $44 million during trial. It would not have been feasible when the claim accrued for the defendants to have put a prejudgment interest amount aside. Also, there has been no case since Hillier in the circuit that has awarded prejudgment interest for non-economic damages.
District courts have, but not our court.
That's correct, that's correct. And the unjust enrichment concept that opposing counsel raised, that makes sense again when there are economic damages at stake, but not when there are non-economic damages. I also want to address the lump sum issue. It's error to find that the award did not include any future damages. That is not a reasonable reading of the record. The jury was explicitly instructed to award any injury that it found he sustained and is reasonably certain to sustain in the future. Juries are presumed to follow those instructions, and during trial there was testimony from three witnesses about Mr. Bolden's experience after he was released from prison. This was front and center. The request was, in closing argument, $44 million for past damages and then an unstated amount for the future. So there's no doubt that the award includes some amount for future damages, and that's ineligible for prejudgment interest. There's also no path here to identify how much of the award was just for past damages. There is no information in the record that could lead to make that determination.
Thank you very much, Ms. Barnea.
Okay,
And thank you very much, Mr. Litoff. The case will be taken under advisement, and that will complete our oral arguments for the day.